force. Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. To my right and your left is Justice William Meade. To my left and your right is Justice Amy Blake. We will be the panel for all 6 cases on the hearing list this morning. The first 3 cases are criminal matters. We will hear argument in those 3 cases and then take a brief recess before resuming with the civil portion of the list. With one exception, in the civil portion of the list, each side has 15 minutes to argue. If you will be arguing with more than one attorney on either side of the V, let us know ahead of time how you'll be dividing your time, and there is no rebuttal. We are familiar with the arguments that you've made in your briefs, and with the factual and procedural history, you needn't go over all of that, and we will have questions for you. As you see on the podium, there is a timer that will count down the 15 minutes. The light will change from green to yellow with a minute and a half left. That's the time to begin wrapping up your argument. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains. And of course, if you reach the end of your argument before you reach the end of your time, you needn't feel compelled to continue speaking. The first case on our list for hearing is case number 2020 P1108. The Commonwealth versus Timothy W. Hayes, and this case is partially impounded.
Good morning, Your Honors. May it please the Court, Megan Siddle on behalf of Appellant Timothy Hayes. I plan to address 2 issues with my time today, the motion to suppress and the sufficiency of the evidence in light of the Commonwealth's of the SJC's decision in Mr. Hayes' co-defendant's case, Ping-Jia Fan. I intend to rest on my brief with respect to the remaining issues unless the Court has any questions on them. This Court should reverse the judgment below because Mr. Hayes was convicted on the basis of evidence that was seized pursuant to an unconstitutional warrant that was not supported by probable cause. There are 2 problems with the warrant here. One is it did not establish a nexus between any criminal activity and Mr. Hayes' home in Gloucester. And the second is the affidavit does not provide any probable cause to support a search of the contents of Mr. Hayes' cell phone. The affidavit here lacks specific information required to show a sufficient nexus between his home in Gloucester and any criminal activity which took place over 25 miles away. So the affidavit is clear that the police suspected prostitution was occurring in Cambridge, North Reading, Quincy, and in Boston, but there's never any allegation that prostitution took place at Mr. Hayes' home in Gloucester.
Isn't he seen on multiple occasions going back and forth to each of these homes, delivering supplies, removing trash that has evidence of sex trafficking?
He is, that's correct, Your Honor, but there's no evidence that any of those supplies or trash were ever located at his home. So, for example, on one occasion, the police follow him from his home to a grocery store. He's seen coming out of the grocery store with plastic bags. He then drives, I believe, to the North Reading apartment and brings those bags into the North Reading apartment and is not seen taking them out back into his car.
Did they already know at this point that he'd written a check to pay for one of the back page ads? Is that in the affidavit is my question, I guess.
No, that's not in the affidavit. I think that was a credit card statement that's introduced at trial, but it's not in the affidavit.
It's a rather extensive operation, right? As you've described it even just now, there were at least 5 separate locations. That's a fairly complex business operation, right?
That's correct.
And so ordinarily, an operation with that many locations would have some central headquarters where there are books and records and proceeds of the business that are kept. There is no particular reason to anticipate that those books and records and proceeds would be stored at any of the sparsely furnished locations where the prostitution was taking place, leaving the most likely venue his home.
Well, I read the record a little bit differently, Your Honor, and I hope I can explain why. So there's nothing specific in the affidavit suggesting that Mr. Hayes' home is that headquarters. And
well, there isn't anything, process of elimination, right? I mean, there was no indication that he rented office space or any reason to believe that there was a reason why he should, if all that was at issue are ledgers and proceeds.
Well, there is specific information suggesting that one other location is where one of his co-defendants resides, which was the Boston location. And I think there's evidence in the affidavit suggesting she's something of a ringleader. So she also has a substantial bank record, and she's herself involved in the prostitution activity. So there's no reason specifically to think that Mr. Hayes' home is the headquarters as opposed to Ms. Pham's.
Well, does it have to be the headquarters or just where there's probable cause to believe there'll be evidence of the crime? Among other things, he's written checks from his checking account that paid the rent at this 5 brothel operation apartments.
He has, but there has to be specific information suggesting that evidence of the crime will be at his home. And the police had already
I mean, that's a small leap right there. Why not banking records at his home? That he paid the rent and utilities on these places.
Well, the police already had obtained his banking records by the time they're applying for the search warrant. They had subpoenaed his bank account, and there's nothing suggesting there would be any additional records located at his home.
Well, other than that someone carrying out a nefarious job as this, that they would keep records secreted in someplace safe, like their home.
Potentially, but I think the case is...
Probably. Just to coin a phrase.
which is less than a probability.
Well, I would resist that phrasing because I think the case is...
Most of the definitions, the definitions are what they are.
Right.
But.
Well, I think the cases suggest there has to be specific information
Well,
in it.
now that you brought up cases, are you familiar with Commonwealth versus Andre Fields that your sister references in her brief? Case out of this court from 2020. Mm-hmm. That the type of crime and the scope of the operation permitted an inference. And I think that's exactly what Justice Meade's question was. Right? It's not necessarily that they're going to find the records that they've already subpoenaed, but how do we know there aren't lists of customers and information getting these women from other states, getting them to Boston to work in the sex trafficking ring? I mean, it's not limited to bank statements, right? We have to look at what the nature of the crime was, and this is sex trafficking.
You do have to look
They have more than a Bank of America checking account, I'm guessing.
There was he had a checking account and a safe deposit box, and Ms. Phan also had several bank accounts as well.
But there are more records than bank records involved in the operation of a business of this type, right?
There are, and there's nothing in the affidavit about those records or where they would be located.
Of course not. That's what they were looking for.
Cell phones, emails. Mm-hmm. He makes several trips to the madam who's in charge, Phan, I believe her name is.
He does.
Have some sort of relationship outside of the business?
Yes, as the affidavit indicates, they were boyfriend and girlfriend. Mm. And he does make several visits to her apartment, including one with a duffel bag.
And there was some indication that she made several visits to his, right?
In the affidavit, there's no indication that she goes to his house, except that at times her car is located there, but he's also seen driving her car at times. There is evidence at trial that she was probably present at his apartment.
What is your strongest case for the proposition that there was no nexus?
I think my strongest case is Steigman, which is cited in my brief. So in that case, there were joint ventures. I think this was the case where there were 2 drug dealers who were alleged to be joint ventures, and there was specific evidence suggesting that there would be drugs located at one of the joint ventures' homes, but there was no probable cause to search the other dealer's home. So, But even if there was a nexus to Mr. Hayes' home,
But the drug cases are different it seems to me, a significant respect, because in those instances, the scale of the business is different. I mean, there are physical locations in multiple towns, and customer lists, computer records for online advertisements, all of which are going to be held by the people at the center of that operation. And if they are both involved, it's reasonable, probable to expect that those records will be present at their homes.
I think it's reasonable to assume that their records would be present at someone's home or at some location, but I don't think there's anything indicating that Mr. Hayes' home in particular is the headquarters of this operation.
It doesn't have to be one headquarters. I mean, to the extent that he is identifiably involved in helping to run the operation, then he could fairly be expected to have some indicia of his involvement at his home.
I think if that's true, then every defendant in every case, the police would be able to search their home?
Every case involving an operation of this scale, right. I think that's right. And that's what Andre Fields seems to say, as I read it.
And I think that would be an extension of the constitutional requirement that there be specific information that evidence be located at a defendant's home.
But it would not be an extension of our holding in Andre Fields.
That's fair.
Okay. As long as we agree that we're on solid ground.
Well, even if the court were to find that there's a nexus to Mr. Hayes' home, there's nothing in the affidavit suggesting a nexus to the contents of his phone. There's two specific allegations about Mr. Hayes' phone in the affidavit. He's seen speaking on his phone in Chinatown outside of Ms. Phan's apartment, and there's a PIN registry suggesting that he's in frequent communication with Ms. Hayes. But as Commonwealth versus... Ms. Phan, I apologize. But as Commonwealth versus Morin holds, being in communication with someone involved in criminal activity does not justify searching the contents of somebody's cell phone. And so the Commonwealth is left with generalized allegations that in this kind of crime, people generally use cell phones and that this particular scheme used back page ads. But there's nothing in the affidavit connecting Mr. Hayes' cell phone to those back page ads. So
his number was included in one of the ads, but the affidavit did not include that reference, is that?
That's correct. His number is on one of the ads that's introduced at trial, but I think they actually recovered that after the search, but it's not referenced in the affidavit. All the ads referenced in the affidavit, the police say that they called the numbers there and someone picked up, but none of those numbers are Mr. Hayes' phone number. And so under Commonwealth versus White, there was no basis.
So how do you distinguish Lowry from last year?
Because, so in Lowry, so there's an undercover who is speaking with the prostitute, and he gives her money. She then texts somebody, then gets a message in return, which the undercover understands to be permission from her quote-unquote pimp to then engage in sexual activity. So there was something very specific suggesting that she is communicating with somebody about this offense. And then there's a search of a car finding a business card that says, that contains the defendant's phone number, and that business card is recruiting women for a prostitution business. There's nothing like that here in this case, in this affidavit.
So if the back page ad with his phone number, if they knew about that beforehand and that was in the affidavit, that would make it more in line with Lowry.
Yes, that's correct, but it is not in the
timing
affidavit.
issue.
That's correct. So. And if the court were to find that the warrant either on his home or on Mr. Hayes' cell phone was executed in violation of the Constitution, it would be the Commonwealth's burden to prove that violation was harmless beyond a reasonable doubt. And I think it'll be difficult for the Commonwealth to meet that burden here, and they really don't attempt to do so in their brief. And in fact, the evidence removed from Mr. Hayes' cell phone was critical to him at trial. That's the only evidence suggesting he had passwords for any of the back page accounts that were used in this account. And the evidence in his home was the only evidence suggesting that he had access to any of the ledgers of the activity that was occurring at these apartments. So without the evidence in Mr. Hayes' home or on his phone, he was much closer to his co-defendant, Mr. Lynn, who was acquitted at trial. Turning to Mr. Hayes' motion for a directed verdict, the evidence was insufficient to convict Mr. Hayes for two reasons. There was no evidence that he had knowledge that what was happening in the apartments was prostitution. And second, the evidence was equally consistent with the defense theory that Mr. Hayes only thought that massage was occurring there, which wouldn't be a violation of the human trafficking statute. There was only one witness.
Well, if you look at the back page ad, there's lots of information in those alone that shows a reason to conclude there was more than massage going on.
Well, all of the customers who testified at trial said that some of them hoped that there would be something more than massage going on, but they understood that they had only booked a massage when they called the ad.
Of course, but there is more than a fair inference from the nature of the advertisements themselves to suggest that more than massage was going on at these locations.
I think there's something in the ad suggesting that the massage was more on the inappropriate and adult side, but there's nothing suggesting that there would be actual sexual activity.
Well, let's talk about the apartments. They're uniquely appointed with a single mattress on the floor, with scantily clad Asian women running around in and out of the place. There's like visits there that last moments to minutes. And then there's the 48 grand in cash in the defendant's checking account. His phone has the back page ad on it. And he's seen coming and going from all these apartments, stocking them with supplies and removing evidence of sex trafficking.
Mm-hmm. He's certainly present. There's no question about that. He's present for brief periods of time. He's not. No one testifies that he's present when actual prostitution is taking place.
Could one not conclude from the single fact that there's these apartments only have one mattress in them, that something is going on there other than massage?
I don't think so. I think there's
certain. It would require willful blindness to walk through those apartments and think that only innocent activity was going on.
I think if he believed that there was, some sort of adult-natured massage happening, I don't think that's willful blindness. I think he simply had a different understanding of what was going on.
He had directions on how to use a condom.
Those directions were in a trash bag.
That he had.
That the police alleged he threw out.
And the supply of condoms is the same brand at each and every house and apartment that he's regularly seen delivering.
That's correct.
I don't think condoms are regularly used in massage.
That's fair, but there's nothing suggesting that Mr. Hayes ever saw those condoms.
Okay, I see that your time has come to an end. Thank you. We'll hear from the Commonwealth.
Good morning, and may it please the court, Nicole Nixon, Assistant Attorney General, appearing on behalf of the Commonwealth. Like my sister, I'll only address the first two issues in the defendant's brief.
Why don't you start with the cell phone?
Yes, Your Honor. There was a sufficient nexus within the search warrant affidavit to establish a connection between the defendant's phone and his criminal activity. Importantly, in my view, is the defendant's frequent communication with co-defendant Fan in this case. I believe it's paragraph 99 of the affidavit shows that Fan's cell phone is in frequent communication with Hayes' cell phone. So I think in that regard, that takes this case out of the context of the white line of cases, where there is a specific connection between the communications and the criminal activity here. Also, the criminal activity is important here to look at. It's human trafficking, and I believe in the affidavit, the affiant specifically details why in a human trafficking operation, communications, but also access to a cell phone where there's online capabilities is important because generally in human trafficking operations, people use Backpage.com, Craigslist.com to advertise their brothel locations and to solicit people to engage in the sexual services.
What made his use of the phone special here, though, or at least indicative of criminal play, in that, as far as I can tell, everyone uses a cell phone all the time, nonstop, 24/7.
That's true, Your Honor, but I think, again, here the nature of the crime, the human trafficking operation, where we're talking about, again, posting things online via Backpage to solicit customers, but also communications between the co-conspirators to coordinate the different brothel locations, to coordinate stocking supplies, bringing females to and from those locations to engage in the sexual services. So I think we have to look at the nature of the crime here, and that's that human trafficking operation. I think that's what takes it out of the context of the white line of cases. If there's no further...
So the suggestion is that for this kind of an operation, it relies heavily on online communications, and online transactions in the case of the advertisements, which are not confined to laptop computers, but frequently conducted by using a smartphone.
That's correct, Your Honor. And indeed, in this case, Backpage.com was the main way the co-conspirators were using to advertise their brothel locations, but also to solicit customers, or at least it was one way.
What was there in the affidavit that connected his cell phone to the Backpage advertisements?
There was nothing specifically connecting his particular phone to the Backpage ads. One of your honors is correct that Backpage ad, that wasn't discovered, the 2016 Backpage ad, that wasn't discovered until I believe after the search of the phone. However, again, I think in this case where there's direct communications between the co-conspirators coupled with the institutional knowledge about human trafficking operations and the way in which they use cell phones and computers to further their criminal conspiracy, I think that's more than sufficient to establish probable cause here. If there's no further
Go ahead.
If there's no further questions as to the nexus between the cell phone, I'd just briefly like to touch on the nexus to the defendant's home in this case. Importantly, in my view, I think is the fact that the affidavit detailed a large-scale human trafficking operation here, and the defendant's
But they already had a lot of the bank records, right, before they applied for the search warrant?
I believe they had some of them, Your Honor. However, I don't think that negates the probable cause within the four corners of the affidavit. When we're looking at the four corners of the affidavit, the case law is very clear that we have to look to see whether there's probable cause to believe that evidence can be found there. The fact that it could be found in other places doesn't negate that probable cause analysis.
So your sister kept referencing that this wasn't the headquarters. You're not suggesting that it was the headquarters, right? Just part of the operation?
That's correct, Your Honor. I don't think that there's any evidence to suggest that the defendant's home in this case was the headquarters. However, I don't think that negates the probable cause here.
So it doesn't matter whether it was or it wasn't?
No, in my view, it doesn't matter. Your Honor, I think that in this type of operation, where it's a large-scale operation, the defendant is directly connected to that, specifically by renting out all of the brothel locations and using the checking account which lists his home address. I think that's more than sufficient to make a reasonable inference that records as well as proceeds from the business would be found in the home.
And what does the trash add to this?
Your Honor, the trash, I think the trash in this case, it's more that the defendant is seen directly going from his residence to the brothel locations and then at times back, exactly, Your Honor, and then back to the residence. I think that the inference can be made that he's bringing supplies into and taking evidence of criminal activity out of the brothel locations, and that could be found in his home.
Well, but the trash bags that he's taking out of the brothel locations are unlikely to be transported into his home. Even if he brought them back to the location of his home, why would he bring them inside? There wasn't any observation that he took them inside? There
wasn't, Your Honor. And I think the larger point with the trash bags is really the driving directly to the residence, from the residence to the brothel locations and then back to the residence. The inference that he's bringing the trash bags inside of the residence that's full of trash, it may not be sufficient standing alone.
Unlikely, certainly not probable.
Yes, Your Honor, but
So the trash bags add very little. It's more the scale of his involvement.
That's correct, Your Honor. And I think, again, like I've stated, the observation during surveillance of him going to and from his residence to the brothel locations and then back to the residence. But that needs to be coupled with the other evidence in the affidavit.
Is Andre Field your strongest case?
Yes, Your Honor, I would say that that's my strongest case.
And what do you say in response to your sister's argument that Stegman helps her the most?
Your Honor, I think the difference with Stegman and here is that there was specific information within the affidavit to show why there would be proceeds and records found in the defendant's home based on the defendant's role, but also, importantly, the fact that he was using that checking account that's linked to his home address to pay for the rental locations as well as the utilities. I think that's what takes it outside the context of Stegman and puts it more within the context of Andre Fields.
Lowry is not quite a fit, I think, here.
I'd agree, Your Honor, that Lowry, in that case, the evidence is stronger to connect the defendant's home, but I do think that there is sufficient evidence here based on what I've just described, the communications and the back page ads. If Your Honors have no further questions as to the search warrant issue, I'll turn just briefly to the sufficiency of the evidence argument, excuse me. The Commonwealth presented sufficient evidence to show the defendant's knowing participation in this sex trafficking scheme, as well as the fact that he knew that sexual activity was occurring rather than just mere massage at the brothel locations. I'd point Your Honors to the 2016 Backpage ad that was posted several months prior to the brothel location's opening. This shows the connection and really the start of the scheme between Ms. Phan and Mr. Hayes, where Ms. Phan's...
In contrast to the ads that were in your supplemental record appendix, the recruitment advertisement was rather innocuous.
Your Honor, I'd say I would disagree with the characterization of being rather innocuous. I think when you look at it as a whole, where it's posted under the adult entertainment section of Backpage.com, and what they're saying, I agree that you have to use inferences to get at what they're saying, but I think those inferences are very clear from the content of the ad. And I do think when coupled with the other evidence in this case, it does show the defendant's knowing participation in the criminal scheme. I'd also just point out to Your Honors the fact that the defendant rented these apartment locations. He was a regular presence at these apartment locations, and as Your Honors pointed out, these apartment locations were very sparsely furnished with just mattresses on the floor in the bedrooms. If there's no further questions, I would rest on my brief and ask that you affirm the convictions. Thank you.
Thank you. Next case on our list is case number 2022-P330, Commonwealth versus Felix S. Moreno.
Good morning, Your Honors. May it please the Court, Mary Miles for the appellant Felix Moreno. Mr. Moreno brings two issues to this Court and asks that his convictions be vacated and he be granted a new trial. If it's okay with Your Honors, I will address the sobriety test issue first. Mr. Moreno argues that the term field sobriety test, coupled with the Commonwealth's questioning about how he was trained in these tests, how these tests determine whether someone is under the influence of alcohol.
Can I stop you there? The motion in limine didn't challenge anything related to the officer's training and experience, right?
So the motion in limine specifically says that the term sobriety test implies a scientific method of measuring a person's sobriety, and an officer testified that he's conducted such a test and a subject failed, that officer's testimony is being offered as a pseudo-expert.
So the goal of the motion was the officer not use the phrase sobriety test.
Because that, coupled with his testimony of the defendant's performance on that test, would change the officer's what should be lay witness opinion into an expert opinion.
The motion does not ask the judge to prohibit testimony on the officer's training and experience.
Well, that would be an inappropriate motion. Of course, an officer is allowed to testify to his training and experience. What he's not...
Okay, we'll get to that later. I just want to make sure what's preserved and what's not preserved here.
Yes, so my position is that it's preserved. I think it's important that an objection is for a judge to understand what defense counsel is objecting to and the evidence that he's trying to admit into court.
It shouldn't be a mystery. The Commonwealth has pointed this out in their brief. So the motion sought to prohibit the use of the phrase sobriety test. And as you just told me, it did not ask for a prohibition on the officer tested about his training experience. So that second claim is not preserved, and it was not objected to at trial. Is that correct?
My position is that,
Just answer the question.
I mean, I don't know, I think you're asking for a yes or no answer.
I am.
And I don't think it can be answered as a yes or no.
Well, it's either preserved or it's not.
Correct, I agree.
And you are asserting that it's preserved.
I am.
But the motion in limine makes no objection on the grounds that you are now raising, and there was no objection on those grounds at trial. So on what basis do you contend that it was preserved if it wasn't preserved by motion in limine or objection?
So the way I read his motion in limine is that he didn't want to transfer or transform the officer's opinion and the use of the field sobriety test into that of a pseudo-expert.
Well, when I read the motion in limine, it doesn't object on the former ground, simply on the latter ground. Now comes the defendant and moves this court to prohibit the Commonwealth witnesses from referring to certain tests given or offered to the defendant as, quote, sobriety tests, close quote. That's the motion. And, I mean, you can say that you think it's preserved, and we get that, but that's not what the motion says.
If this court doesn't believe the issue is preserved, I still believe it creates error.
A substantial risk of a miscarriage of justice, okay. But,
Correct.
and we have your argument on that.
I thought you just told us that it would have been inappropriate to prohibit an officer from testifying about his training and experience.
Well, his training and experience as an officer, but the Commonwealth consistently asks the first question the Commonwealth asks of is, did you have occasion to be trained in operating under the influence investigations? And then he asks, what are field sobriety tests? The trial counsel objects, and then he goes into extensive explanation as to what a field sobriety test, how he was trained in those field sobriety tests, how they trained on live subjects, and then when he forms his opinion, and then he goes into discussing how Mr. Moreno failed those tests, and then when he goes into his opinion, the Commonwealth says, after you asked the defendant to perform all these tests, did you form an opinion? And he said yes, and then he goes through the officer goes through the factors upon which he performed that test, including his performance on the field sobriety test, and then he formed the opinion that the defendant was intoxicated. I think Canty points out that once you start asking an officer specialized training as to field sobriety tests and what those field sobriety tests indicate to an officer, especially when coupled with the terms of under the influence, it then transfers his opinion as that of an expert.
Canty says that the officer can't testify that the defendant was driving while impaired. Canty specifically allows the evidence on the opinion of the officer that the defendant's under the influence, and that's a lay opinion.
Correct, but I think the issue is that when a prosecutor continually asks about this specialized training in detecting whether or not someone is under the influence, and part of the specialized training is these so-called field sobriety tests, and then highlights that in the prosecutor's closing argument as this is how the officer is taught how to detect if someone is under the influence, and it's no longer a lay opinion.
But you don't rely on Canty for that. You rely on a dissenting opinion in Commonwealth versus Gallagher.
No, I rely on Canty footnote 5 that says a prosecutor who elicits from a police officer his or her special training runs the risk of transforming the police officers from a lay opinion to that of an expert, upon which is subject to a different standard. That is what I rely on. And then Gallagher, Agnes's dissent, talks about how perhaps we should find a way to limit an officer's testimony or find a way to alert the jury that, if we're going to testify this way.
Well, dissents don't offer any precedential value.
No, absolutely not. No, that's very true.
Do you remember who
You're
wrote?
talking to
Do you remember who wrote the majority?
Exactly. No, so I'm well aware. Yes, I'm well aware of that. Yes. So, and I understand your Chief Justice. You wrote the opinion in Dow, which was not available when I wrote my brief, and that opinion also does mention that an officer cannot testify to any specialized knowledge or training, and just like that case where these officers testified in Dow to the live subjects they used.
Do you know how many convictions by this court or the SJC has been reversed based on Canty?
That would be a 0.
Yeah, very good.
There's got to be a first, right? No. But no, that would be a 0. But I have noticed that in the opinions coming There were recent opinions that this seems to have been an issue. Prosecutors eliciting these specialized training by officers to somehow give the jury the impression that this evidence isn't lay opinion.
If the prosecutor didn't ask the officer about his training and experience in conducting field sobriety tests, what do you think is going to happen when the defense argues it in front of the jury? What are they going to say?
Defense argues what? That there was no?
He has no idea how to do these tests. He didn't have any training or experience. This is guesswork.
Well, I mean, I think it's important for an officer and the prosecutor to relay to the jury that these field sobriety tests, as this court and the SJC has stated, is that they measure someone's balance, someone's mental acuity, someone's coordination. They don't necessarily detect someone, whether someone is, if you fail, they're therefore under the influence.
That goes to weight, not admissibility, and all of the contributing indicia of how much weight the lay juror can place on the administration of a field sobriety test by a police officer depends in part on the training in how to conduct those tests. Let's talk about the terminology, because I was intrigued. I mean, you know, these, if it was a field intoxication test, the term might be a little bit more loaded, but of course that's what the test is designed to measure, right?
Well, the test is designed to measure, as we said, someone's mental acuity, someone's coordination, which, as a layperson understands, alcohol diminishes that ability. So one could, from his performance on those tests, could then infer that his motor skills and, you know, mental acuity has been diminished, and therefore, perhaps, based on other indicia, his ability to drive has been impaired.
Did smash into the car in front of him at a stoplight.
I don't know if I would. Someone say smashed, I would say.
The car in front of him.
Correct. The car in front of him didn't go. He was talking to his girlfriend.
Damage to his car, glassy-eyed, slurred speech, smelled of alcohol.
Couldn't point to the location of the damage when he was questioned by the officer.
Couldn't recite the alphabet, couldn't do the 9-step walk.
Well,
couldn't do the one-leg stand.
No, and that is, I agree with all that. However, I would state that Mr. Moreno did testify as well as his girlfriend, and I understand this goes to, you know, credibility. However, he did give a plausible explanation for all of that. His English isn't his first language. He doesn't know the alphabet, so you can't fault him for that.
Did he testify with an interpreter?
No, he did not. But that doesn't mean he knows the alphabet. He also did testify that...
He did not suggest when he was asked that he did not know the alphabet.
That is correct. I would also suggest that he, according to Mr. Moreno and his girlfriend, that he'd been up since, 6 or 7 that morning. He had been with his friends. He had been driving back and forth. It was late at night the next morning. He was tired. It's also a roadside at after midnight. Perhaps
Of alcohol.
He said he had one drink.
10 hours earlier, he said. He still smelled of alcohol.
So the Commonwealth mentions that in their brief, but there's no scientific evidence to say that it's, for some reason, its odor of alcohol diminishes within hours.
Sometimes good old common sense works.
If we're using good old common sense, my husband can wake up the next morning and he still smells of alcohol, and that's, you know, more than 10 hours earlier. So common sense is common sense, but you can't rely on that.
Well, no, but that's, of course, a question of fact for the jury to assess. Going back to the question of the label assigned to the test, in this context, was there any particular concern that the jury was going to be misled by the use of that terminology into interpreting the performance on those tests as something other than what they were?
Well, I think while your honors don't believe it was preserved, and you say...
the sobriety question.
No, that issue. So I say
I'm talking now about the preserved issue on sobriety.
So I mean...
The label unduly prejudiced the defendant?
So I think the argument's relatively the same as the unpreserved argument. The officers, you know, testified, you know, to doing all these training on these live subjects, so gave them some sort of specialized training. The Commonwealth in its closing argument says specifically, he was trained in the indicators to look for when someone is under the influence. He's trained to give field sobriety tests, which are tests that give someone roadside to sort of see, engage, try to help them understand whether or not someone is under the influence. I would say not in all cases does the term field sobriety test indicate or could nudge a jury to believe that this is expert opinion. However, I believe in this specific case, given the prosecutor's questioning, along with the Commonwealth's focus on these tests and how he was trained, could easily for a jury give them the impression that for some reason these are, tests that are.
Except, doesn't the judge instruct them to just the opposite, that you give these tests whatever weight you want?
Yeah, I mean, that's true. And I understand, again, that the decisions have said that those general instructions are.
Gallagher says that, I think.
Oh, Gallagher, yes, and that's what, but I again rely on Justice Agnes's dissent in saying perhaps if there's a question of expert opinion, there should be some sort of instruction to let the jury know that, this is not expert opinion, this is observations of a lay witness, and this is his opinion.
You want to talk about Downs? The Downs instruction?
Oh, yes. So the Downs instruction, I would argue that this was obviously analyzed under substantial risk of a miscarriage of justice. It was not preserved at trial. Trial counsel was unprepared. He was unaware of the Wolf decision when he went to trial. There was no discussion with the court or defense counsel, or more importantly, defense counsel and the defendant, about whether or not to give this instruction. The defendant was denied this opportunity because of counsel lack of preparedness.
The concern in Wolf is that that instruction, in the absence of any particular focus on the presence or absence of a breathalyzer test, could place inappropriate attention on that topic. In this case, unlike in Wolf, there was a question from the jury about that very question. So the risk that Wolf is concerned with was not present in this case, and Wolf specifically includes language appearing to carve that out, doesn't it?
Wolf says that even with the instruction from the jury, the decisions should still be left to the defendant. It's very similar to a defendant's right to testify and whether or not to instruct the jury on that.
It actually says that it's the better practice.
Correct.
They never say it's error to give this instruction.
No, they don't say it's error, but in this case, because defense counsel was not prepared, did not know the relevant case law, the defendant was denied the opportunity to make that decision. And the court, no one ever really discussed whether or not to give this decision.
But where's the substantial risk, as the chief put it, in other words, that their jury's attention was already drawn to the fact that he didn't take a breath test because they asked about it.
Correct.
And therefore they were already focused on it, unlike in Wolf, where the SJC's concern, leading to them suggest what the better practice would be, is to not give this instruction without a request, because it would improperly, or it could get them to focus on the fact they didn't take a breathalyzer.
I would argue that the jury the jury was not already sold on the defendant's guilt. They had come back with a question. Second, they had already not followed the jury instructions by focusing on the lack of breathalyzer. I would also argue that in terms of evidence, it was not nearly as compelling as that in Wolf. The defendant, in Wolf, she drove erratically, she couldn't park her car, she had said she consumed alcohol, 3 drinks that evening.
Did she hit another car? Did she hit another car?
No, she just was driving erratically and couldn't park her car the way the officers had asked her to park her car.
That's your time has come to an end. Thank you for your argument. We'll hear from the Commonwealth.
May it please the Court. Assistant District Attorney Chi from Middlesex on behalf of the Commonwealth. Field sobriety tests measure a person's balance, coordination, and acuity of mind. And the lay jury understands that intoxication leads to diminished balance, coordination, and acuity of mind. Since Candy, it is well established that testimony about field sobriety tests is lay testimony. And this Court has unpublished opinions consistently told the Commonwealth officers can testify to their training experience in conjunction to the field sobriety tests. In Mercia in 2015, where Justice Blake was part of the panel, that case held that it was proper for the officers to testify to their training experience. The real question really here is whether that training experience would blur the line between a lay or expert testimony here. Unlike Dow earlier this year, where Justice Green was part of the panel, in that case, Dow, the officer based his opinion of intoxication on the training experience, which is different from here. What Candy in footnote 5 and Gallagher was warning the officers or the Commonwealth is do not base your opinion on the training experience, and that's missing here. Here, the officer properly testified to his training experience, which is relevant to the weight of the testimony this Court has 2001 case shoot to point out a failure to adhere to standard field sobriety tests goes to the weight of the testimony, as Justice Meade talked about earlier. All this will show that the officer properly testified to his training experience. In terms of the term field sobriety test, the jury understanding was about sobriety. Like the defendant was charged with OUI, all the testimony was about the crash, the other signs of intoxication. They would know it is about intoxication. In terms of whether this term should be allowed moving forward, in Gayhart, the SJC had opportunity to review that term. In Gayhart, the SJC found that in terms of OUI drugs, in terms of marijuana, we should use the term roadside assessment, and it said approvingly about the term field sobriety test in terms of intoxication. And this court has no reason to question the SJC's decision in that. And in Hamilton, 2012, where Justice Green was part of the panel, that panel also approvingly held that it is okay to use the term field sobriety test. So there's no error in terms of these two issues. When it comes to Downs, the motion judge, who was also the trial judge below, did not make a finding in terms of performance, which is the main reason why the Commonwealth did not argue that. There's no substantial risk of miscarriage of justice. And this court does not reach the question of Downs because, one, it's not raised directly from my sister's brief. Second is, there's actually going to be a case in front of this court. It will be briefed by the end of the year exactly on this issue, how the court should treat footnote 13, where the court, in the Wolf court, say the concern about Downs is it will draw the jury's attention to the absence of BT. But footnote 13 at the same time says to the jury, if the jury has a question, the judge should, it's a better practice for the judge to refrain from giving the Downs instruction. However, that better practice dicta in footnote 13 is really unrealistic because the jury had known about it. They will not forget about the question simply because they asked about it. And this court does not need to reach that question because there's no substantial risk of miscarriage of justice. The case was overwhelming. Unlike Wolf, the defendant failed 3 field sobriety tests repeatedly. The defendant crashed from a stop position and could not point out where damage was. This case is overwhelming, although not required to be. So there's no prejudice whatsoever.
So I'm sorry if you said this already, but in Wolf, in addition to unless requested, the SJC also said unless there's some set of facts that directed the jury's attention to a breathalyzer not being taken, which seems to be the case here.
Certainly, and that's exactly what happened because the jury draw their attention to the absence of BT. It could be any other reason. It could be the common knowledge about the field sobriety test. Bottom line is the Commonwealth position is this court does not need to reach that question. This court will have the opportunity to reach that question on how to distinguish footnote 13, and hopefully the SJC will address that issue at some point, but that case is Commonwealth v.
We don't have to wait for the SJC. We get to decide questions too.
Absolutely, Your Honor, especially
They're very
when it's
busy down there.
Especially it's footnote 13, it's a dicta, and there's no guarantee the court is actually going to adopt that dicta that was held 5 years ago. If there are no further questions, the Commonwealth rests on its brief.
No, thank you.
Thank you. The next case on our list for hearing is case number 2022, P166, the Commonwealth versus B. Van PHAM. And just as a reminder, we will take a morning recess after the conclusion of the argument in this next case.
Good morning, Your Honors. If may it please the Court, my name is Shane Surratt, and I represent B. Van PHAM, the appellant, before the Court. I would like to address 2 arguments that are contained in my brief, the first being the one pertaining to associational evidence, and the second pertaining to the opinion testimony. As it pertains to the associational evidence, I would suggest that the introduction of the associational evidence at the appellant's trial created a substantial risk of a miscarriage of justice.
I'm so confused by this argument. This was an undercover buy, right? Nothing more, nothing less. I don't understand the associational. I actually had to look it up because I'm not sure exactly what that is. The officers testified to what they did, the call that was made. the transaction occurred, it was observed, an undercover bought it, the money that had been pre-marked was found on him after. This seems like a red herring to me, so help me understand it.
That's correct, Your Honor. And I would just note that the evidence introduced that it was a high crime area, that Mr. PHAM.
So let's take that factor out. Everything else is still in.
Well, I understand, Your Honor, but with that in there, along with the fact that the gentleman lived in the area, coupled with the testimony that a call was made to a number known to belong to Mr. PHAM, to order drugs.
Yeah, but they didn't say that he's associating with the criminals in the community.
Right.
They say it's his phone number. There's actually an agreement before trial, right? That they're not going to explain why the police know it's his phone number.
That's correct.
So this was done by agreement.
That's correct, Your Honor. But what I would note, though, is that they're not going to say pertaining to how they got the phone number, but the testimony comes in that they know it belongs to B. Van Pham.
Well, sure, because they called that number and said, will you come sell us drugs, the nice undercover officer? And lo and behold, Mr. Pham shows up and sells drugs to the undercover officer, just like was arranged on the phone.
That's correct, Your Honor. But part of the issue is that the officer testifies that I knew the number belonged to B. Van Pham, and then the other testimony came in that the purpose of calling the number was to order drugs from this individual.
But even if it didn't belong to B. Van Pham, they made a call. You're not questioning identity. B. Van Pham shows up, takes the drugs out of his mouth, gives them to her, takes the money, and that's the marked money. So, I mean, I know you argue in your brief that really the whole issue here is the police officer's credibility, I guess, but tell me how, and your sister raises this in her brief, how does this suggestion, I think that you're making that they knew he was a drug dealer, and the evidence was such that he was a drug dealer, how does that impact the police officer's credibility when in fact he sold drugs?
Well, I think it goes to the issue of basically piling on. It's a situation where if the credibility of the officers is...
Piling on evidence of guilt?
Well, point taken, Your Honor, but piling on so much as associational evidence, because if, you know, and I cite...
Associational evidence is a label, and I agree with Judge Blake in her observation that it's not terribly helpful to understanding what we're talking about here. The evidence that you seem to be raising concern about, first of all, there was no objection. Second of all, we would review, even if there were objection, for abuse of discretion. The evidence is principally directed toward describing how the sale, that is the center of this prosecution, was arranged. It provides context for the sale that resulted in the defendant being found in possession of the marked bills used to purchase the drugs. It seems rather straightforward to me, the entirety of the presentation of evidence.
Judge, the case was obviously pretty quick, and I think it was only about 2 hours to try, my understanding of the transcript.
Right, so then even if we were piling on, it didn't pile on for very long.
True. But what I would note, Judge, is I know the label of associational evidence, but I draw the court's attention to Commonwealth versus Meade, and I apologize if I butcher the name on that one, but it's contained in the brief.
From 1975?
Yes, Your Honor.
But that case was about a defendant that had repeatedly been seen in an area where heroin was commonly sold, and arrests for selling heroin had been made overly prejudicial. Is that the testimony we had here?
Judge, I would say, like in similar to in Savidum, it's a situation where in that case, it's my understanding that there was observations of a buy made to a state police trooper. So it's a situation where you have a similar scenario, and that court found error in there because of the high crime area and indicating that the gentleman had been seen in that area on numerous occasions. You have a situation here where Mr. Van Pham, it's described as a high crime, high drug area with robberies, shootings, etc., but it's also described as Mr. Pham lives in the area. So I would just suggest,
And if they had nothing else, I think I understand your argument. They can't arrest him just because he lives in a high crime area, or that there are lots of crimes occurring in the area that this takes place, but he sells the crack to the undercover cop.
correct. But I would just note that I don't think that in and of itself eliminates this case from the similarities of Commonwealth versus Meade, which did overturn the conviction in that case. I would just note again, if it was just a situation where we're describing it's a high crime area and that's it, my argument would obviously be less powerful, less impactful, but I would suggest we have the evidence that he lives in the area, that it's a high crime, high drug area, that they watch him leave the location that he lives at and go to the exact location. So this isn't just a situation where you can just say the gentleman lives in the area, so a lot of people live in the area, so it's not really an issue. They actually watch him leave the residence that they say he lives in, go exactly to the meat location, and conduct this undercover sale. So I would suggest that I know the associational evidence, as the Chief Justice Green described it, a label, but I would also suggest that consistent with Commonwealth versus Meade, and I know it goes back to 1975, it's a situation where that I would suggest piling on, and as Your Honor described it, piling on of guilt, I would suggest
Well, that's
is an
what
error.
prosecutors do. The burden of proof beyond reasonable doubt is very high. So they put in the evidence that they can.
Correct. But it also has to be evidence that should be admissible as well. I would suggest that.
Well, I mean, they didn't convict Bevan Pham because he associates with drug dealers. That would be improper. They convicted Bevan Pham because he himself is a drug dealer.
Well, they convicted him because of the sale that they purportedly observed.
Yes.
So it's a situation where, if that were the case, but it's also the evidence comes in that this gentleman is living in this high crime area, that this gentleman is seen coming from his residence, goes to this meat location.
Can I push back on that? Because at transcript 77, Turgeon testifies that one time that the area where the drug deal took place was known to him as a high crime area. He said that once.
I believe it said in the brief where he says that it's a high crime area known for drugs, prostitution, and robberies, is my
The area
understanding.
where the drug deal took place was known to him as a high crime area. So he said that one time, right? The transcript says what the transcript says. But I still come back to, I think, where I started, which is, at the end of the day, he sold drugs to an undercover police officer, regardless of where it took place, how they got the phone number, whether he hung out with good people, bad people, or no people, he sold drugs to an undercover.
Point taken, Your Honor. But I would just note that.
And I appreciate you're in a tough spot because it wasn't preserved. I do appreciate that.
Right, and it's a situation, Judge, where it wasn't preserved, and it's just hard to say that you can look at that in a vacuum, so to speak, where you have this undercover sale, and if that's it, that's the Commonwealth case, that's the end of the story. But you have a situation where there's what I would suggest this extraneous information coming in, of which wasn't objected to, that kind of adds to the equation.
Well, then let's go to that, right? Because you allege ineffective, but am I correct that there was no motion for new trial?
You are correct, Your Honor.
Okay, so what is it that is readily observable in the record that would cause us to rule that there was ineffective?
And I understand, Your Honor, it's obviously a better scenario in a motion for new trial, but I would suggest it's applicable here on the record, notably, number one, the lack of any objection to what I've characterized as the associational evidence. Similarly, Judge, would kind of lead into my second argument is the opinion testimony where the lieutenant testified. He described a typical street-level drug transaction, and then I would suggest not only he went beyond comparing it, because he was asked, is that what happened here by the prosecutor, and the prosecutor said yes, where he described a transaction.
The officer said yes.
The officer said yes, yes. It's a situation where the prosecutor asked the officer, and the officer described a typical drug transaction where they'll get a phone number for a suspected drug dealer, which by inference would be Mr. Pham. They call that number, which they knew belonged to Mr. Pham. They arrange for a drug sale, and then this gentleman shows up and meets them at a meat location.
So why is this case any different than the cases that we refer to sort of the silent movie of a drug transaction?
Well, I would suggest, Judge, because in this scenario, the lieutenant who testified to this didn't actually observe the transaction take place. He testified.
Well, he was away from the transaction, but didn't the undercover testify?
The undercover testified to what, right.
What
correct.
happened?
Correct. But I would suggest they went one step further when they're offering this opinion testimony from the lieutenant, where the lieutenant then goes on to describe a typical drug transaction, and then he was asked by the prosecutor, is that what actually happened here? And the lieutenant testified yes, where he described ordering drugs.
And which case, most closely analogous to this one, resulted in a reversal of the conviction based on that sort of evidence?
Based on the opinion testimony?
Well, you're calling it opinion testimony. The testimony of this type.
Judge, I would say, and I cited Commonwealth versus Woods in my brief, where it was an opinion ultimately of whether a drug transaction had occurred. And I
But that's different, right? Because here there was no assertion by a so-called expert that, in his opinion, a drug transaction occurred. We don't need that because we got the undercover cop saying that he, in fact, engaged in a completed transaction purchasing drugs from this defendant.
Well, and your point's well taken, Mr. Chief Justice, because I would just note that they didn't need that, but they went that step further and actually.
But they didn't go there. I mean, not only did they not need to, but they didn't. They didn't say, it's my opinion that a drug transaction took place. He's describing the common characteristics of a drug transaction.
Correct. He describes the common characteristics, but I would suggest he goes further. He says, describes a typical drug transaction, describes buying from a drug dealer, contacting a phone number, and then when the prosecutor asks him, is that what happened here, the officer replies, yes. So he's now comparing the two and linking the two.
Which the jury can do as well. I mean, but he's identifying the elements that characterize a typical drug transaction, and then he is able to answer truthfully that each of those characteristics is present in this scenario. He does not go to the next step and say, in his opinion, a drug transaction took place, which is what happened in Woods, and he doesn't need to because the undercover officer who actually engaged in the drug transaction testifies that he engaged in a drug transaction.
Understood.
So there is no substantial risk of a miscarriage of justice in the face of that evidence because the evidence of guilt was overwhelming.
Well, I would just note, as I did in the brief, I mean, I know that the description of whether it's overwhelming, I would just note that there was no DNA evidence or fingerprints.
I don't fault you for making the argument that you feel you need to make. Anything further?
No further questions. I would rest on my brief.
Thank you.
Thank you.
For the Commonwealth?
Good morning. May it please the Court. Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this Court to affirm the defendant's conviction where there was no improper introduction of any associational testimony and where the defendant has failed to establish that his trial counsel provided ineffective assistance. As was discussed previously, the admitted evidence, which was overwhelming, provided exclusive context of the sale with the undercover officer, and the defendant was not convicted on the basis of any sort of association with any other individual or any affiliation with an area or a location of the city. Regarding the testimony that the defendant was arrested in an area known to have a high crime rate and known for drug dealing, this was proper as well. Unlike the case cited, again, apologies for my mispronunciation, Sesamtim, none of the officers testified that they had previously seen the defendant in the area where drugs were commonly sold or where they frequently arrested individuals for drug dealing. None of the officers said that the defendant had committed any prior bad acts or that they were familiar with him from any prior dealings. Regarding Lieutenant Hanlon's proper description of a street-level drug transaction, again, as previously discussed, Lieutenant Hanlon did not express his opinion that any drug sale occurred. He specifically outlined the steps that the officers take to conduct an undercover buy, and then agreed that those were the steps that were followed by officers on the date in question.
Did he use the magic phrase consistent with?
I would have to check the transcript, but I'm pretty sure the trial attorney just asked, is this what happened on July 31st, 2018? And Lieutenant Hanlon said yes, but I'd have to go double check. Moving to the ineffective assistance claim, as discussed, the defendant cannot prove that his trial counsel exhibited behavior that fell measurably below that which might be expected for an ordinary lawyer. It's likely that the trial counsel knew that the so-called associational evidence was indeed admissible and objecting would have been futile. And there was ample evidence viewed in the light most favorable to the Commonwealth to support the conclusion that the defendant did distribute a Class B substance. The officers were working in cooperation with the undercover officer. They arranged the transaction for the crack cocaine to be purchased from the defendant. They placed the call to the defendant, agreed on amount and location. 15 to 20 minutes later, the defendant appeared at that location, spit something from his mouth into the undercover officer's hand, exchanged previously marked bills, and after the transaction, the defendant was arrested, and the officers found those previously marked bills on his person. If there are no further questions, the Commonwealth would ask that this court affirm the defendant's convictions and the Commonwealth would rest on its brief. Thank you.
Thank you. We will be in recess. We will resume at 5 minutes of 11.
All right, please. Court is in recess. Is there anyone else that needs to start with TERSLY versus DECHERT?
Continue our list with case number 2022 P76 TERSLY Investments Limited versus DECHERT LLP and another.
May it please the court. My name is Christopher Hines, and I represent TERSLY Investments Limited. This is a case that presents a years-long conspiracy between a former co-shareholder, a private equity investor, and a global law firm to deprive my client of its early-stage investment in cheapflights.com. The co-conspirators worked together to prevent TERSLY from discovering the true value of its stake in Cheap Flights, resulting in the denial of TERSLY's rightful share of a $550 million transaction. The amended complaint's well-pled allegations plausibly suggest an effort to use unfair and deceptive trade practices, namely fraud, deceit, and strategic misrepresentations and omissions, to deprive TERSLY of the benefit of its bargain for deferred consideration. DECHERT played its part by aiding and abetting its client's fraud, keeping TERSLY in the dark about facts basic to the settlement of its deferred consideration rights, and Great Hill assisted this scheme by intentionally delaying the completion of the 2017 sale to BHI, giving Highlander and DECHERT just enough time to negotiate and execute the settlement. This was not just a lawyer vigorously representing its client. It is a lawyer acting as a co-conspirator with its client in perpetuating a massive fraud and succeeding.
You are describing a fraud at the center of your claim. The principal protagonist in the alleged fraud is not a party to this action. Is that correct?
That's correct, yes. Highlander is not subject to jurisdiction here in Massachusetts, but a lawsuit has been initiated in the UK, or it is shortly to be initiated.
The nature of that fraud, let's, even though Highlander is not a party to this action, let's look at, because it seems to me that in order for you to establish that DECHERT facilitated a fraud, you need to establish that a fraud occurred.
That's correct, yes.
So what is the what are the specific contours of that fraud perpetrated by Highlander?
So we allege that Highlander committed fraudulent non-disclosure. Non-disclosure amounts to fraud when that non-disclosed fact is basic to, or it goes to the essence of the transaction.
If I purchase an asset from another party, possessed of knowledge that I can sell that asset for more than I'm purchasing it, does my failure to disclose what I know constitute a fraud?
It does if you have a duty to inform the other side of the party.
That begs the question, right? Let me just restate the question.
Okay.
If I purchase an asset, knowing that I can resell that asset to another party for more than I'm proposing to buy it, does my failure to disclose my knowledge of my ability to resell the asset for a higher price constitute a fraud?
If you pass on partial information to the other side.
No, let's start with the basic premise, okay? I mean, the answer to the question, of course, is no, correct?
Correct, yes.
Okay. So in order for the situation I've just described, where I buy low and sell high, to constitute a fraud on the purchase side, I must do something to mislead my counterparty on the purchase.
That's correct, yes.
Okay. And the mere fact that I don't disclose knowledge that I have is not an affirmative misrepresentation or misleading, right?
It's not an affirmative.
So what is, in your well-pleaded complaint, the allegation that constitutes the affirmative act of misrepresentation that turns this buy low, sell high into a fraud?
Well, the fact that in May of 2015, DECHERT passes on its client Highlander's assertion that...
Let's talk about, I want to talk first about Highlander, because everything that DECHERT could potentially potentially, I mean, I think you've got a higher bar with DECHERT than you do with Highlander.
We do, yes.
Because they are representing a client. But we'll get to that later. I want to get to the foundational premise of whether there was a fraud at all.
Well, because Highlander said that there was uncertainty as to whether or not they were going
Was that untrue at the time that statement was made?
It very well may have been untrue. We do not know at this point in
This
time.
market in 2015, there was a great, I mean, it was nothing if not uncertain.
That statement of uncertainty, if it was true at the time, eventually...
Is there any allegation or other evidence that would indicate that it was untrue when, I mean, you're not asserting that the statement was knowingly false when made?
No, but it became false as time went on.
Once they identified a buyer, of course the uncertainty dissipated.
Right. And
but where does the duty arise? I'm going to go back to my sort of threshold hypothetical.
Right.
I mean, they were engaged in some form of speculation, right? Trying to buy low and sell high, and the fact that they were successful in doing so doesn't require them, in my ordinary understanding, to disclose the fact that they found a willing buyer at a higher price at a later date.
We contend that when it disclosed the initial information that there was uncertainty whether or not another sale was going to be forthcoming, and that if Highlander and TERSLY were going to settle this deferred consideration dispute, TERSLY would have to take a haircut. There would have to be a substantial, substantial discount.
Right.
So,
and as circumstances changed on Highlander's side of that equation during the ensuing negotiations, which took quite a long time.
we do not know how long they took. We know.
Well, we knew that they started in 2015 and they didn't conclude until sometime in mid-2016, right?
Oh, the negotiations between Highlander and TERSLY.
Yeah.
Yes, that's right. There was an 18-month period where the two parties were exchanging communication.
So circumstances changed for Highlander, and at least for their part, they were no longer uncertain.
That's correct, at some point in time.
And you contend that once they determined that the market was no longer uncertain, it was incumbent on them to disclose that new knowledge, that change of circumstances, to their counterparty on the settlement negotiations.
Yes, that is our contention.
I know that's your contention.
Okay.
Where is the authority for that proposition? Where's the duty?
In a case, Computer Sales International v. Lycos, which is a case, a District of Massachusetts case, it says that a party who discloses partial information that may be misleading has a duty to reveal material facts to avoid deceiving the other party.
Those are conclusions, and well, I mean, I'll start with the obvious observation that was, I mean, I respect our counterparts over in the Federal District Court, but they are not binding appellate authority.
That's correct.
But you're baking into the description the fact that it was misleading. Again, I'll go back to the threshold proposition that you're not alleging that the statement concerning uncertainty was untrue when made, much less knowingly untrue when made. And so the question I'm asking is a different one than you're answering. The question I'm asking is, from what source, what authority does your assertion that there is an affirmative duty to disclose new information that changes the circumstances under which the parties entered into negotiations?
Well, a case from this court may be more applicable than one from the District of Massachusetts. Stalzoff v. Waste Systems International. That's a Massachusetts appellate court case. And in that case, they found that non-disclosure of a fact that is, non-disclosure may amount to fraud where that non-disclosed fact is basic to or goes to the essence of the transaction. The amount...
Again, those are conclusions that the duty has to arise from a source. The duty would, if there were a representation made at the outset on which the counterparty relied, be a different story. This was a statement of fact that was true at the time regarding something that in the absence of an actual deal, was almost always going to be true, that there is uncertainty about the future.
Right, and that statement, whether it was a statement of fact or a statement of opinion as to these future events, that can be actionable where one party possesses superior knowledge concerning the matter which that misrepresentation relates to.
It wasn't a misrepresentation because it was true when made.
It may have been true when made. We don't know whether or not.
Not alleging that it wasn't true when made. And so it later became untrue because of a change in circumstances. What was once uncertain became known.
That's correct, yes.
And I'm asking you a different question than one that calls for a statement of a legal proposition that puts you into the box where you want to be. I'm asking you for any case where a change in circumstances like this gives rise to an affirmative duty to reveal the new information to your counterparty.
The argument is just the ones that I've made thus far.
So you're arguing based on legal propositions, but none that draws from facts like these?
We don't have a case that is factually...
that doesn't surprise me, actually.
Okay.
Okay.
Can I ask a completely different question?
Sure.
So in their brief, DECHERT says, yeah, even if you were right, it's barred by the litigation privilege. And you touch on this in your reply brief, but I want to understand what your argument is as to why it doesn't apply.
Sure. So we would contend that there are two reasons that litigation privilege is inapplicable here. First, the privilege's applicability depends on a conclusion that DECHERT's communications were made preliminary to a proposed judicial proceeding. That type of a conclusion requires a finding of fact, and dismissal on that issue would be inappropriate without further development of the factual record in this case.
So the judge didn't reach that question?
No, the issue was not brought up in the lower court. Litigation privilege only arose in the appellate brief, yes.
So is it waived?
We did not contend that the issue was waived. The second reason is that a reading of Flores that DECHERT proposes would essentially obliterate the Massachusetts rules of professional conduct that bar attorneys from participating in their clients' fraud and deceit. Nothing in Flores overrules, nothing in Flores overrules relevant case law which holds that a lawyer can be liable to a non-client for fraud or aiding and abetting its client's fraud. Those would be the two reasons why we believe that litigation privilege is inapplicable here.
If we were to somehow conclude, I don't know that we would get there, but if we concluded that there was no fraud and we somehow reached the litigation privilege question, would your answer be different, or does your answer depend on a conclusion that there was fraud?
Sorry, could you say that again?
Sure. If we were to conclude that there was no fraud and somehow we still reached the question of the litigation privilege, does your argument stay the same, or the fact that if we were to conclude there was no fraud, we wouldn't reach it?
Yes, I think that if there's no fraud there, that doesn't change the two arguments for litigation privilege's inapplicability in this scenario. That's my position, yes. If there are no other questions about litigation privilege, I would also contend that despite the questions posed here, we believe that DECHERT did aid and abet Highlander's fraud when it made its uncertainty statement and it failed to correct that uncertainty statement over the 18 months of negotiations when it became clear that that uncertainty statement was no longer true.
Did you make any separate argument about the interference with advantageous business relations, or no?
It's very much wrapped up in the fraud allegation. There were not They are not
That was a
derivative.
separate count, right?
Yes. It's.
Did you brief that separately?
We did in the lower court. We did not brief it in the appellate court. The decision from the business litigation session dealt primarily with the fraud and whether or not Dechert's duty of confidentiality would have prevented it from disclosing the fact that there was, disclosing the fact that another disposal of the cheap flight shares was in the offing.
Thank you.
Thank you.
I understand that the co-defendants will be dividing their time.
Yes, Your Honor. May it please the court, Richard Zielinski, and I'm here with my partner, Dennis King. Together, we represent Dechert, and by agreement, we'll take 9 minutes of the 15 minutes, and Mr. Pirozzolo will take the remaining 6 minutes for Great Hill. Your Honor should affirm the decision below for 4 principal reasons. I want to start with the litigation privilege, which Judge Blake raised. I'm sure Your Honors are familiar. This was a sweeping decision that the SJC came down with in July of this year. All of the claims in this case, we say, are barred by the litigation privilege. There are 2 aspects of that facetious...
But can we reach that if it wasn't argued below?
Yes, Your Honor, you can. Under
How?
Leading Supreme Court Judicial Court authority, Your Honor can affirm this decision based on any grounds that the record will support. And as counsel said, they're not arguing that the issue was waived. So there are 2 aspects of facetious that are critical here. First, facetious clearly held that the litigation privilege applies not just to statements and conduct in the litigation, but communications and statements that lead up to the litigation. This court has had occasion to apply facetious in the few months that it's been out. And in one of 2 unpublished opinions, Barnes versus Johnson-Neisser, a case almost identical to this one, the court relied on a series of letter writing that led up to the filing of litigation and statements and facts disclosed and undisclosed in that letter writing. Clearly, that is the record here. The trial judge found, and the record absolutely supports, that from the beginning of the letter writing in this case, in May of 2015, all the way up through the settlement of this case, this was a dispute, claims were being made, accusations of breach of contract, all leading up to a formal settlement agreement. So clearly, that test is met. And the second part, equally important, facetious was crystal clear that the litigation privilege applies not just, as may previously have been thought, to defamation claims, but to all tort claims against an attorney. Facetious involved claims of fraud, just like this case. It involved claims of conspiracy, just like this case. It involved claims under Chapter 93A, just like this case. Facetious was decided on a motion to dismiss. No discovery, no fact-finding. I think the SJC, and by the way, this is the culmination of 30 years of jurisprudence. The SJC said it is absolutely clear that especially in an adversary situation, we need bright lines that will not expose a lawyer to claims by his adversary. That puts the lawyer in a hopelessly conflicting position vis-a-vis the duties that they owe to their own client, duties of confidentiality, duties of zealous advocacy. Secondly, as Your Honor has rightly pointed out, this is not an affirmative misrepresentation case. That issue has been muddled in the plaintiff's arguments from the day they filed this case. But the trial judge couldn't have been clearer. There was one and only one alleged affirmative misrepresentation, and that was the uncertainty statement. And the court held as a matter of law, applying this court's reasoning in the Stolzoff and the Zimmerman case, a prediction, an opinion about future events cannot, as a matter of law, be the basis of an affirmative misrepresentation claim. The plaintiffs conceded at oral argument below, as Your Honors pointed out. They have no evidence that that statement was false when made. When pressed by the trial judge, they admitted there was no DECHERT undertook no continuing obligation to update or refresh or supplement the uncertainty statement. So this is purely a non-disclosure case. And as your honors know, historically, non-disclosure wasn't even a tort in Massachusetts until Massachusetts adopted Section 551 of the Restatement of Torts, which has very different and stricter obligations, which brings me to my third and fourth points. The undisclosed information here about the potential future sale was immaterial, given the claim and the arguments that TERSLY was making. What do I mean by that? The claim that they made was that they were entitled to all of the deferred consideration based on a sale that took place in 2014. DECHERT, in its original letter, May 15, said, well, wait a minute. Our client didn't sell all of their stock in 2014. They only sold 44% of it.
But they had an interest in participating in any future sale of whatever remained.
Not based on, they might have, but that's not the claim that they made. TERSLY's claim from day one, and it never changed. We are entitled to 100% of our deferred consideration. That meant that any future sales, whether they occurred or not, whether they were certain or not, were irrelevant.
Well, but no, the part of the global settlement was designed to foreclose any future claim that they made one claim as part of the settlement negotiations. But a waiver of any future claims was a part of the settlement, and understandably so.
Yes, it was, Your Honor, but keep in mind, the settlement gave TERSLY 100% of their claim for the deferred consideration based on the 2014 transaction. So they never relied, whether future sales were certain, uncertain, made no difference to TERSLY's claim.
The uncertainty about the future sales and future prospects was a part of the premise for entering into those negotiations. That otherwise it wouldn't have been included in the uncertainty statement, setting aside whether it was a basis for a claim of fraud.
That was Dechert's and Highlander's position.
I
It was never TERSLY's position.
I understand, but they didn't surrender that. The settlement was designed to get them to surrender any future claims.
Yes, it was, Your Honor. And there's a second reason, by the way, why the non-disclosure was immaterial, and the trial judge picked up on this. He said in footnote 1 in his opinion, he found it significant that in the settlement negotiations, TERSLY never asked. They claimed they relied so heavily on this uncertainty statement made years earlier, but the trial judge pointed out, they never asked Highlander to make a standard representation or warranty in the settlement agreement that there were no other sales that were contemplated. On the contrary, the settlement agreement, if you read it, affirmatively disclaims reliance on any representations or warranties. That's right there.
I'm sure there was a reason for that.
Well, they signed, if they were relying on some continuing obligation, they could have just asked.
You can understand their disappointment.
And my last and final point, Your Honor, the trial judge relied on 30 years of jurisprudence in Massachusetts, case after case, SJC and this court. We are not going to impose a duty on a lawyer to disclose confidential client information to an adversary. That's the Lamar decision. It's the Robertson versus Gaston Snow decision, and it was recently affirmed again in Beseches.
Before you lose your time, counsel, do you think that the interference with advantageous business relationship is before us?
I believe it's been waived, Your Honor. It was not mentioned at all in the appeal, in the issues presented on appeal, or in appellant's brief. But just think about the implications of imposing that obligation on a lawyer. Any lawyer, it would put a lawyer in a hopeless situation. Anytime I'm negotiating a settlement on behalf of my client, I would have to think to myself, what do I know from confidential communications with my client that the other side might think important, that might cause them to change their claim or amend their claim? It's an impossible situation. And this court and the SJC has said, we're not going to put the lawyer in that position. Thank you, Your Honor.
Thank you. Mr. Pirozzolo?
May it please the Court, Jack Pirozzolo on behalf of Great Hill, and with me is my colleague Alex Kellerman, also on behalf of Great Hill. Thank you, Your Honors. I want to just start by clarifying what was not ever alleged against Great Hill. Great Hill, there was never a claim for fraud against Great Hill. The sole core allegation against Great Hill was really this intentional interference claim. That was the central claim, which at this point is no longer a part of this case. It has not been briefed on appeal. I know that there's a footnote. I believe there's a footnote where the plaintiffs have tried to roll it up into an allegation related to the 93A, but that's not even remotely what's required in order to preserve the issue here on appeal. And that's for good reason. There was never any improper motive or any improper means alleged at all with regard to Great Hill. The sole allegation against Great Hill related to the decision to extend a due diligence period out twice. So the original letter of intent was in October. There was an extension, there was a 60-day due diligence period. There was an extension in December and another one in January. So December 2016, January 2017. That's it. That's it. And that was contemplated in the letter of intent. That's actually alleged in paragraph, I believe it's 118 of the complaint. And so there's no dispute that there was a contractual right, if you will, to extend the due diligence period that Great Hill had at all times. And the plaintiffs are trying to convert that indisputable right that Great Hill had to extend the due diligence period, even if it were in order to make sure the deal closed, into an unfair and deceptive business practice. Originally, it was framed also as this intentional interference, and then it's rolled up into the conspiracy. But it's all derivative of this notion that somehow it was improper for Great Hill to extend the due diligence period, which, by the terms of the complaint...
Suppose Highlander asked Great Hill to extend the due diligence period as an accommodation in order to facilitate its realization of the lower settlement cost with Tersley.
Let's just, so of course there's no allegation of that, but let's assume that to be true. That would not change the analysis. And the reason it would not change the analysis is because understand that the due diligence issue is between Great Hill and the buyer, Priceline. So all that would happen is Great Hill goes to the buyer and says, do you want to extend the due diligence period? We need to extend the due diligence period. That buyer, who's not a party to this case, no allegation that they had any objection, in fact, ultimately agreed to extend the due diligence period. Again, it was entirely within Great Hill's rights vis-a-vis Priceline to be able to extend the due diligence period.
I understand that, but if they were doing so for the purpose of benefiting Highlander and placing it in an advantageous position vis-a-vis Tersley on the settlement.
That would not be an improper purpose at all. And why is that? Why is that? Because it's entirely appropriate for Great Hill, if it perceived it to be within its own economic self-interest to do so, the case law is clear that that is not an improper purpose. Let's say it was to harass or somehow threaten Tersley in some respect. I mean, that's where you talk about sort of where this intentional interference case law goes, which is not really...
You could imagine it as being not designed to target Tersley so much as to benefit Highlander.
Well, then, to benefit Highlander is not an improper purpose. It's not, because, and again, really, I think what the case law is trying to get at here is let's sort out ordinary rough and tumble economic activity here. And an agreement to benefit Highlander would be within the scope of things that would ordinarily be rough and tumble negotiations. Tersley is well represented throughout this. They had the ability to negotiate. And
I have a different question, though, before you lose your time, which is, Tersley agrees that they're not in privity of contract with your client, but they cobble together this term, commercial relationship. Can you address that?
Yeah, so under the case law, the way the case law construes commercial relationship, even though under 93A, it's a 93A question, with regard to 93A, even though under Section 93A there doesn't have to be a contract, there still has to be some kind of transaction. So, for example,
There's just nothing here.
there's nothing here, absolutely nothing, not even an allegation that Great Hill had any sort of transaction at all with TERSLY. TERSLY was a shareholder in a dispute that went back 20 years, really, between 6 and 20 years with Highlander. Great Hill happens to have people who are on the board of directors of the entity, which, by the way, isn't even a defendant in this suit, that was ultimately sold to
So is this
Great
just
Hill,
buyer's
to
remorse in your
Priceline.
view?
Seller's remorse.
Or seller's remorse?
You could characterize it that way, I suppose, yeah.
Well, they
Left a lot of
if
money.
circumstances were different, they would have realized a good deal more money, and there's always a little bit of remorse around that.
But I want to be clear here. I don't think it's fair to characterize Great Hill as being engaged in any kind of sharp practice or anything like that. Great Hill was above board in all respects here. There's no allegation, really, genuine allegation to the contrary. Thank you.
Our next case is case number 2022 P426, the University of Massachusetts Amherst and another versus Adams Plumbing and Heating, Inc., and others. We have allowed a motion by the parties to permit an additional 5 minutes per side, and understand that the defendants will be dividing their time. We also have denied a motion for rebuttal time.
We are going to clear the courtroom, it seems, with this case. Need a bigger courtroom.
Bleachers.
We need more chairs. Is that game? Musical chairs, Mark.
Good morning. May it please the court. Lauren Coppola for appellants UMass and UMBA. With me are my colleagues Rebecca Bacht and Melissa DeLelio. This case is simply about the enforcement of contracts. The appellees made a series of express contractual promises to and for the benefit of UMass and UMBA.
You've dropped the negligence claims, right?
Correct, Your Honor. Risk allocation and what the parties were going to provide. These were contractual obligations that were triggered, others were breached, and UMass and UMBA are entitled to pursue these contractual causes of action. This court should reverse the lower court's erroneous decision to dismiss both causes of action, contractual indemnity and express guarantees, as time-barred, and remand the case to proceed with discovery, which was never conducted. This court's review is de novo. I will first focus on the indemnity claim.
Can I ask, and maybe you don't know because I don't believe you were counsel below, but why did you wait so long to bring this? I mean, you knew in 2018 that the ductwork had collapsed, I think, is what the allegation is. And then you wait 3 years to bring a complaint?
With all due respect to the lower court's counsel, Your Honor, I don't know that the answer to that question.
I know it might not be a fair question, but I'm sorry.
But I will submit to you that the date of the filing of the complaint to reinstate the contractual indemnity claim and the breaches of the express warranties is of no consequences. Those causes of actions were filed in a timely manner. And that's what the court's inquiry should be this morning.
If they're expressed.
If they're expressed, correct, Your Honor. So if I may first focus on the contractual indemnity claim. There's a group of 5 entities that promised if UMass suffered a loss, it would pay for it. These are sophisticated parties in the construction, design, and building industry which negotiated and agreed to risk allocation. But the Superior Court wrongly, and for the first time ever, made a bright line distinction about this contractual agreement.
You're aware that of the line of cases that say that a contractual agreement to perform work does not transform from a negligence action into a contractual action, the negligent performance of the work performed under that contract, right?
Your Honor, there are cases, there's a line of cases which say that if the parties did no more to then agree to the standard duty of care, that does not constitute...
And we'll get to that question, I assume, when you start talking about the express warranty. But for the moment, on the indemnity claim, the terminology and labels that I saw in the briefs and in some of the cases that distinguish between first-party and third-party indemnity, it seems to me are not all that helpful. But what seems to me to be the animating characteristic of that distinction is an indemnity for damages required to correct defects in the work itself, or damages caused to other persons or property by defects in the work.
Well, here, Your Honor, we have 5 very broadly drafted indemnity provisions, which permit...
But the nature of the underlying, I mean, they will also be subject to the statute of repose to the extent that they don't go outside of the bar against claims, the gist of which is negligence.
I disagree, Your Honor. So the case law supports my position in that whatever conduct triggered the contractual indemnity provision is an irrelevant and inappropriate inquiry. And this is where the lower court respectfully erred. As Gomes says, the SJC says, the parties freely and intelligently entered into a contract of indemnification. They should be held to it. Again, the underlying conduct, whether it is negligence or a tort which triggers the contractual indemnity, is inappropriate and irrelevant. We have 5 broadly drafted contractual provisions for indemnity. Those, as the SJC has held in Gomes, are contractual provisions, causes of actions of which the gist is contract and inapplicable, the statute of repose is inapplicable.
But the underlying damage for which you seek recovery is defect in the work itself, correct?
It's a variety of reasons, Your Honor. It could be negligence, it could be breaches of contract.
But let's get to that. I'm just talking about the nature of the injury. Okay, the source of the financial loss is confined to defects in the work itself and the need to remediate those defects, right?
In that the various parties breached specific promises to deliver a product.
Okay, but that we're going to talk about promises when you get to the warranty. I just want to get to the loss, the injury for which you are seeking recovery.
The losses, right, stem from...
The work itself.
Correct, Your Honor.
Okay. And now I'm going to ask you, you've offered a lot of labels to say that this is contract and not negligence. But setting aside for a moment, we're going to talk about express warranties. Why you are so certain that that damages to the work itself make an indemnity provision different from negligent performance of the contractual obligations itself. I mean, if there's an express warranty, that's a different matter, and we'll talk about that. But it seems to me that an indemnity against negligence doesn't transform negligence into contract.
Well, Your Honor, the Gomes case, again, the SJC case right on point here, involved an indemnity provision nearly identical to ours and an underlying...
The loss was not to the work itself. Well, the loss was, and again, this goes to the distinction that I said earlier is not all that helpful, but it's collateral damage.
I understand your point, Your Honor, and I would refer the court to Lennar, the BU case that we've relied upon, and the AC Moore case that we've relied upon. And those are, Lennar 2, for example, Your Honor, it was demasked by Judge Burroughs, and it was a first-party indemnity claim.
I have all the respect in the world for Judge Burroughs, but if you were here earlier, you also heard me comment on the fact that those decisions are not binding on us.
I understand, Your Honor.
You rely on a lot of unpublished decisions.
We relied on a lot of other decisions because there's not, Your Honors, there are no cases cited by anybody in this case before you where a contractual indemnity cause of action is covered by the statute of repose, whether or not the injury was related to the work itself.
There's not a lot of published authority for the proposition that you're pressing either.
Your Honor, I would submit that Gomes is applicable here.
I understand, and that is a place where we do disagree.
The appellees are asking this court to reverse Gomes.
No, we're
I would
not.
submit.
No. I think there's a distinction in the nature of the indemnity that was at issue in Gomes from the indemnity that's at issue here.
The indemnity provisions are broadly drafted to cover first-party and third-party claims and all causes of actions, claims, liabilities, and losses.
But Gomes did not involve a first-party loss.
But it did not make a distinction that limited its application, and in fact, the indemnity provision was identical to the one here.
When you look at the underlying source of the injury, it is a backdoor attempt to convert a claim, the gist of which is negligence, into a claim sounding in contract. Judge Kaplan, when he was here, used to say you should never place too much reliance on the forms of action in that Yoda-like way that he was so fond of using. And we really are looking through those labels, whether it's a contract or whether it's an indemnity provision within that contract, if the underlying claim is shoddy workmanship. And so now why don't we use that as a segue to get over to talk about your express warranty, because that is a different independent claim. What is the nature of the warranty that was made in this contract that takes you outside of the line of cases that says that general agreements to perform work in a contract are subject to the standard of care and therefore negligence in substance?
Absolutely, Your Honor. So as I think we've all agree on, the express warranties are not covered by the statute of repose. And the Superior Court overlooked express guarantees in the contracts and specifications. And I can go through some examples. Adams promised a complete and operable demand ventilation exhaust system with certain precise airtightness requirements and completing the work in accordance with provisions of the specifications. This language...
That's general contract language that appears in virtually every construction contract.
I disagree, Your Honor.
Treating that as an express warranty would eviscerate the statute of repose.
So the promises that Adams make, Your Honor, I would submit are very much like the promises for a complete and operable system like in Coca-Cola, or the airtightness promises that are identical to the airtight plenum express warranty in the Massachusetts highway case. Lee Kennedy also promised a project that is complete in accordance with contract documents and fully operational in all respects. Again, fully operational was enough in the Coca-Cola case to get the case to the jury, as well as a fully operational promise in Mosasian. A promise by Brunner Cott to be responsible for professional and technical accuracy of the service rendered. These are nearly identical to Town of Hopedale's express guarantees. As this court knows, the inquiry is whether the standard that was breached is set by law or set by contract. And I would submit that there are the cases that we rely upon wherein parties breach or alleged to have breached specifications constitute breaches of express warranties. TechOn, again, proposed to perform testing and provide a balancing of the air system in conformance with particular codes and standards. These were intentional agreements to abide by handbooks.
Did any of them include the word guarantee?
Your Honor, I don't know that right off. There are many contracts and specs. And I think my point on that issue I'll make is that before you in the appendix, there are hundreds upon hundreds of drawings and specifications. These are beyond the standard of duty of care. They're express promises to deliver a product. And in fact, in our briefing, we highlighted for the court the various instances in which the standard duty of care is simply re-articulated. So there are places in the contract where it says, so-and-so contractor sub will perform in accordance with the standard duty of care.
The Coca-Cola case, is that broad in the guarantee?
Yes, Your Honor, and I also may submit on the Coca-Cola case, there were promises that were oral in nature. So this case was dismissed before any discovery was conducted. And so in many of the cases upon which we rely, there were oral promises. I will submit that not all of the specs have been produced in the case because, again, there was no discovery that was permitted to move forward. And so at the very least, this court should remand so that the full universe of contract documents and specifications for this complicated project are explored for the various breaches that
we have. Excuse me. We have the contracts. Isn't it a question of law whether there's an express guarantee?
We have the contracts, but within the contract documents, Your Honor, is incorporated the specifications. So, and the various specifications, I would submit we do not have all of.
And this is, I'm sorry, and then this is something you brought to Judge Deacon's attention.
There was an affidavit, Your Honor, that was submitted by the prior counsel on the limitations of the specs and contracts.
When does a construction contract not include the specifications for the work?
You're asking a factual scenario where there are no specifications, Your Honor?
I'm not sure I even understand. I mean, I used to do a little bit of this stuff, and
now you're in trouble.
It seems to me that a contract sets out the specifications for the work that is to be performed. If inclusion of specifications in agreement to perform and to complete the work in accordance with those specifications constitutes an express warranty, then the statute of repose would have no applicability to any work performed pursuant to a contract, which is surely not the legislative intent.
Well, the statute of repose makes sense in that it protects a universe of professionals for an unknown, length of time for negligent work. Shoddy work. Specifications are particular intentional promises to deliver a product. You could have a contract where I say, Your Honor, I'll build your house and I'll do it in accordance with industry standards. Or I'll do it in accordance with my duty of care.
That contract?
But
I
understand.
I want to know what the cabinet pulls look like.
Exactly, and that is a specification for a promise of a specific result. And if I didn't deliver you those particular cabinet pulls, that is an express warranty that was breached. And it makes sense that that's not covered for the statute of repose. You intentionally promised me a specific type of cabinet pull. So you're on notice that you could be exposed to a claim for not providing me that specific
Cabinet pulls are probably
cabinet.
not the best example because the obvious deviation from the specifications would be apparent within the 1-year express warranty period under most construction contracts. The statute of repose abrogates the discovery rule otherwise applicable in a claim for negligence, and there could be latent defects and latent specifications, I suppose.
That's right, Your Honor. And here I will submit that there were specific promises for results that in accordance with the case law of Coca-Cola, Massachusetts Highway, Town of Hopedale, that Mosian, Lemrise, promise to deliver a specific result, even in compliance. Lemrise, I'll submit, there is compliance with sanitary codes that was
For a
promised.
moment, let's just say for the moment that if the specifications required the use of a particular component, okay, and a different component was substituted without agreement by the university, which specific claims of loss in your complaint fit that category, where there is a deviation from the specifications as opposed to a failure to perform the work in a good and workmanlike manner?
Well, I would say both, Your Honor, the breach of the express warranties.
No, I'm asking you to identify an example of a deviation from specifications by substitution of a different component or part from what, because as a matter of legal theory, it's very interesting to have this conversation about specifications. I want to know if it attaches to any facts in this case.
I understand, Your Honor. I think what you're asking is, can I point to a factual example of where a deviation from the specs resulted in the loss? And what I will submit to you is that because this case did not proceed after, really just the complaint and the pleading period, there hasn't been discovery where I can identify a specific legal allegation.
Injury. I mean, if you're seeking to rest on a claim that there was a breach of an express warranty, you need to identify what that breach was.
Yes, Your Honor, and we've identified not a deviation from the spec, but various specific promises that each party made. That's
a different theory from the one that we were talking about just a moment ago. You were talking about specifications and talking about the Coca-Cola case in that regard. What are the promises, apart from specifications, that give rise to an express warranty?
Yes, Your Honor. So there, as I began to list off before, there are promises in the underlying contract, not the specifications, to provide a complete and operable ventilation system. That's an express promise in the contract, which under the case law, a breach of...
Which case? Because that's...
Coca-Cola, Your Honor.
Where does Coca-Cola say that?
Sure. I'll be happy to... Give me one moment. Okay, I'm on, so the discussion in Coca-Cola begins on page 12 of the decision.
I have it.
Okay. And
Coca-Cola argues that the defendant expressly warranted that the wastewater treatment facility would ultimately treat wastewater within the permit requirements while the issue was closed, right? Okay.
Right.
That's what you're talking about.
And then it said, he assured me, so the end of that next paragraph, Your Honor, where they're talking about testimony, he assured me that this system was proper, that it would work. Given the ongoing, the case goes on, given the ongoing problem of complying, blah, blah, KGN could...
But that set a standard of permit requirements as opposed to a general good and workmanlike...
Right, that the system would work, that it was operational.
All right, well, we have the contract, we have your brief. We have the contracts, I should say, and we have your brief. Thank you very much.
Thank you for your time.
Okay, and we'll hear from the defendants. I understand that Mr. Graceffa will go first with 6 minutes. Is that correct?
Yes, Your Honor. Thank you. May it please the Court, John Graceffa here for Adams, and I'll be speaking on behalf of Adams and the other co-defendants in general in regard to the express warranty questions.
You're all going to have a relatively brief period of time, so I will encourage you to get right to the chase.
Record Appendix Volume 3 contains the specifications. It's 154 pages long. The specifications in this are laid out in detail. It's a standard construction contract, which is a spec. There's
Justice Meade asked a question, does the word guarantee appear anywhere? No. Does the word warranty appear? Yes, it does. It appears on page 16 of the specifications. It's a 1-year warranty expressed for product.
Standard.
That's it. And under the cases, starting with the Anthony's, or starting even before that with Klein, and moving up to Coca-Cola, there were assurances well beyond specifications. When the vessel turned over and sank in Boston Harbor in the blizzard of 1978, the history of that was that Anthony, the owner, had questioned the owner of Crandall Dry Dock Company as to whether or not that construction would withstand tides and twice-a-year tides. He said he wanted to put other cluster pilings there, and Crandall Dry Dock said, you don't need it. Coca-Cola, there were assurances beyond the contract. Mosekian, the word guarantee was in there, and there were assurances that the foundations and the pile driving equipment was appropriate. So, Justice Green, I think I'm going right to the point. As I think you've pointed out, this is custom and practice in the insurance industry. The specifications are normal. If this court were to hold that specifications were statute of repose resistant, then the statute would just be gutted. There would be virtually no situation where a specification would not be construed as some type of express warranty. You can't read into this contract the word guarantee. It is not there. You cannot read in the word warranty.
If the contract specifies copper pipes and the contractor instead installs PVC, that would be a deviation from the specifications. And I can understand why that might be actionable, because it was a promise to deliver a specific product and a breach of that promise, and therefore it's contractual in nature and not negligent.
Yes, but that's not the situation here. The claim here is that, at least as to Adams, the claim is that under this air tightness specification that we breached that. That's still a question of fact, but assuming that's true. That's a specification in this contract that the system would achieve 1% air tightness. Does not say that Adams is going to guarantee that the system is going to be 1%. It's not warranted to be 1%. That is a guarantee. It's, Your Honor, just like an X-ray welding certification on a piping and a sprinkler system in a building. This system shall comport with standard X-ray specifications. But unless the word guarantee is in there, or we warrant, don't turn that spec into a warranty or a guarantee. I just think it's just misreading the contract and the intent of the contract. The Coca-Cola case, again, and I followed along with the discussion, once again, as on page 129 of the decision, and I was assured time and time again that this system would work and there was no need to try something else. Just like in the Anthony's case, there was an assurance. There was a question and an assurance back. That did not occur here. Adams, and to the best of my knowledge, no other defendant in this case made any assurances, warranties, or guarantees off of the contract. The professionals, the engineers and the architects, they had a standard of care in the contract. The general contractor, Adams, and our subcontractors all had specific specifications which we were required to comply with. The simple case is that we did not make an express guarantee at any point to UMass. It's not in this contract. And I think, once again, to go back to where I started, I think it's very telling that had they wanted to put a warranty provision or a guarantee provision in this 154 pages of the HVAC specifications, that it certainly could have been in there, but it doesn't exist. It doesn't exist. And I think the Superior Court got it right. It was a very well-written decision. He went through all of the contracts, cited the appropriate language in each, and found that there was no representation that amounted to a warranty or a guarantee. So I would ask this court respectfully to affirm the decision of the Superior Court on all grounds, and I think I'm getting to the end of my time, and unless there are any questions, I will retire.
Thank you. We have Attorney Kelly for Garcia, Galuska, and D'Souza, Inc., with 2 minutes coming up next.
Good morning, and may it please the court. Kristen Kelly St. George, along with Catherine Kenny, on behalf of the defendant Garcia, Galuska, D'Souza. I have 2 points to make in my 2 minutes, which have to do with the plain language of the contract, both with Garcia and some of the other defendants. First, I'd like to draw to your attention to the only 2 contractual provisions that the plaintiffs have pointed to in the Garcia contract that allegedly provide an express warranty. The first, which is section 2.1 of the contract, says the consultant shall perform its services consistent with the professional skill and care ordinarily provided by professionals practicing the same or similar locality under the same or similar circumstances. The statement is not an express warranty, but rather states the work of the professional will meet the standard of care, the negligence standards set by law. The second provision that the plaintiffs have pointed to is that Garcia contracted to essentially assist Brunner Cott with their work on the project. They point to sections 3.1 and 3.1.5 of the Garcia contract. Again, this is not an express warranty because it doesn't promise a specific result. It doesn't say a certain state statute or code is going to be complied with. As such, the claims that the plaintiffs have brought against Garcia are torts that are barred by the statute of repose. The second argument relates to the fact that you don't even have to get that level of detail to get rid of this claim. And that's because there is no contract between UMass Amherst and my client Garcia Galuska, and that's similar for a couple of the other subcontractors on this case. Plaintiffs have tried to get around this by arguing that they're third-party beneficiaries of some of the contracts. However, UMass has not pointed to any specific language in any of the contracts that expressly provides that UMass or UMBA is a third-party intended beneficiary of any of the
In section
contracts.
10.4, you actually have the language that says that
Yes,
there
so
are
in
no-
Garcia's case, we actually have the language that says there are no third-party intended beneficiaries.
Thank you.
Thank
Next,
you.
we have Attorney Donovan for Lee Kennedy for 4 minutes.
Good morning, Ann Donovan, Your Honors, and I represent Lee Kennedy, who is the general contractor. I just want to point out 2 specific parts of the Lee Kennedy contract that just emphasize why the claims of UMass must fail. First, in our indemnity, we exclude property damage to the work itself. Work is capitalized, itself is capitalized. And to ignore that provision would completely make that language superfluous, which we don't do when we interpret contracts here in the Commonwealth of Massachusetts.
Just to be clear, there is no allegation of damage to other property other than the work itself or to other persons.
Correct, Your Honor. It's exclusively to what they allege, inadequate kitchen exhaust system. The other part, Your Honor, which I'm not sure if you'll get into because the lower court didn't reach it, and I know Your Honor said the first and third party difference isn't that important, but our contract...
I didn't say it wasn't important,
Okay.
I just said it wasn't illuminating.
Okay.
For these purposes.
Let me make it illuminating, Your Honor. Our contract, literally, I'm going to use the word screams, third party only. The first part of it says that we will indemnify and defend with counsel acceptable to the authority. So we're going to indemnify and defend with counsel acceptable to the authority and keep and save harmless the University of Massachusetts. That is blatant third-party beneficiary language. I'm the daughter of an English teacher. That introductory paragraph covers the whole paragraph. And the other part at the end is sort of interesting too, and I'll say shout instead of scream. Shout's third party only, and it has that 149.29C saving language that if UMass is solely negligent, then we don't have to indemnify. Again, that only pertains to third party situation. So the other important part I want to direct the court to is actually the plaintiff's complaint. If you look at their complaint, which they're not, they didn't appeal for the negligence ruling, but if you look at their negligence and their breach of contract and their indemnity, They literally all say the same thing. And that is that UMass alleges that Lee Kennedy breached the contract and the indemnity agreement by failing to provide construction services with due care and diligence in a workmanlike manner and in accordance with the degree and skill of similar professionals. Exactly what they allege in negligence, exactly what they allege in breach of contract, exactly what they allege in the indemnity claim. They're bound by their allegations in their complaint, and the judge below did a very reasoned decision. He talked about the history of the statute of repose, and that if you can take an indemnity and claim negligence through indemnity just because it's in a contract and completely abrogate the statute of repose, that would defeat the entire purpose. And the case law recognizes it can be a tough decision. There can be latent defects you don't even find out about until after the statute's run. Here, as Your Honor pointed out, it was put in September 2nd of 2014. By the spring of 2018, UMass knew they had a problem.
The briefs and the judge's decision in the trial court make no mention of the SJC COVID tolling orders. I take it that's because the tolling orders speak only to statutes of limitations and not statutes of repose.
Yes, Your Honor, as a group, we did research on that, and that is correctly right. I have 15 seconds. I can make fun of Gomes, Your Honor, and only being cited 7 times in 32 years because it was my case. I walked up here and got it as a first-year associate. It was 2 pages. I went back to the office bitterly disappointed it wasn't more, and my partner said, they decide what they have to decide. They decided what they had to decide, which was third party. The statute doesn't apply to third party indemnity.
Thank you.
Thank you, Your Honor.
Attorney Sweeney for WSP. And you have 3 minutes.
3 minutes, Your Honor. Thank you, Your Honors. Chris Sweeney for the appellees WSP, which was the commissioning agent on this project. I'm here to speak to 2 issues that are unique to the WSP contract. The first is that there's absolutely nothing in the WSP contract that could even remotely be construed as providing a specific promise or guarantee here. In fact, the best that UMass can muster, and this is on page 44 of their brief, is that the WSP contract had a provision that said that WSP would provide an opinion on the equipment as installed and whether it complied with the plans and specifications. But nothing in the contract required that WSP guarantee that its opinion would be correct or that the equipment would function per the plans and specifications. Instead, the only allegation is that WSP failed to comply with those obligations by failing to comply with the standard of care. That's a classic negligence claim, and it's barred by the statute of repose, regardless of what UMass chooses to call it. And I note that during argument today, UMass referenced the Adams contract, the Bruner contract, and the TCON contract, and there's also some language cited in their reply brief that make no mention of WSP's contract because it's clear that there's nothing in there that could even remotely be construed as a guarantee or a promise to achieve a specific result. My second point is on the language of our indemnity provision. As I think Lee Kennedy just argued, there's nothing, or the indemnity provision in our contract screams as being applied only to a third-party claim as opposed to a first-party claim. And that's because our indemnity provision requires us to defend, indemnify, and hold harmless. If the claim, if the provision were to apply to a first-party claim, there would be no reason to include the term defend in there, and accordingly it should be construed according to its terms as the case law is clear, and the court should conclude that even if, generally speaking, a third-party indemnity claim may evade the statute of repose, the language at issue in our contract is not susceptible to that same interpretation. And for those reasons, I will rely on my briefs, and we ask the court to affirm the dismissal order in favor of the WSP defendants. Thank you.
Attorney Laughlin for left field for 3 minutes.
Good afternoon, Chief Justice and Your Honors. May it please the court. My name is Sean Laughlin on behalf of Left Field. I think I'd like to begin first by just echoing what I think Attorney Sweeney just mentioned with respect to the express contract discussion earlier, and just briefly note that I don't believe I heard either an express promise anywhere in Left Field's agreement either, because I don't think one exists. And I think that's a good segue to the point that I want to address here with you, which is unique to Left Field's agreement, and that is Article 11.1, which was Left Field's indemnity obligation. Left Field is required to indemnify the University of Massachusetts, but only to the extent that the damages that arise out of that claim are caused by Left Field's negligence or breach of contract. This creates a proportional indemnity obligation, as this court set forth in North American Site Developers back in 2005. It requires a showing of causal fault before the indemnity obligation triggers. Now here, judgment has entered in favor of Left Field on the negligence action, and judgment has entered in favor of Left Field on the breach of contract action. And therefore, the proportional indemnification obligation for Left Field here is 0% or $0, however, whichever metric you would choose to measure that by. North American Site Developers involved a very similar contract clause and discussed a scenario in which the subcontractor's employee had sustained an injury on a work site, and the subcontractor and GC above them sought full indemnity after the personal injury case reached a verdict. And I believe on appeal, we saw that this court had reversed the trial court's ruling that full indemnification would be provided to the sub or the general contractor because there was a percentage by which the subcontractor was responsible in the underlying claim. Therefore, the indemnity obligation was limited to that percentage in the underlying claim. And I think it's directly analogous to what we have here. And just quickly to point out, in UMass's reply brief, they really only addressed the Rush v. Norfolk case in response to this argument, and they sort of brush right past North American Site Developers. And in Rush v. Norfolk, the reason why, again, to the point that evidence of negligence can be presented even if there's no cause of action of negligence, well, in that case, similar to North American Site Developers, there was an underlying action that had already reached a verdict. Therefore, there was a finding, there was evidence presented, there was a negligence case that was tried to verdict. Here, there is none because judgment has already entered in favor of Left Field. And secondly, the proportional obligation in the Rush v. Norfolk case was an act-based indemnity clause. This one, once again, is negligence-based, which necessitates a finding. And for those reasons, we'll rest on our brief and the arguments advanced by prior counsel. Thank you.
Thank you. And that brings us to the final attorney representing the defendants, Attorney Howard for Brunner-Codd.
Good afternoon. May it please the court. Eric Howard on behalf of Brunner-Codd Associates. I want to address three issues. One, the argument that Gomes created a bright line rule. A plain reading of Gomes confirms that it's limited to the facts of that case. Moreover, the indemnity language in Gomes is much different than the indemnity language, for example, in the Brunner-Codd contract. They're not identical as suggested by the appellants. Three, the suggestion that Brunner and Codd provided a guarantee or express warranty, and they cite to Article 1.8 of the Brunner-Codd agreement. And all that provision does is just confirm in writing that Brunner-Codd is vicariously liable for its subconsultants. That's all it does. It doesn't provide any guarantee or warranty. It just confirms that it's responsible for its subconsultants, the technical accuracy and the services provided by its subconsultants. That's it. It doesn't provide any warranty or guarantee. And there's no other provision of the Brunner-Codd contract that provides any warranty or guarantee. And the other thing I just want to say as we close out this oral argument, UMass had a fully operational system for 3.5 years. This is much different than the cases they rely on where the project failed at the inception. In other words, it never worked, whether it's Coca-Cola bottle or it's the Hopedale decision or it's the other decisions they cite in their brief. All of those cases, the project had problems from the inception. That's not what happened here. They had full operational control, maintenance, and use of that system for 3.5 years. And I'll rely on the arguments in the Brunner-Codd brief. Thank you.
Thank you. That concludes the argument in this case. Thank you. It's very helpful on both sides. The final case on our list for hearing this morning is case number 2021 P945. This matter is impounded, and it involves a sex offender registry classification.
Was the appellate version of speed dating?
Bill, some of them stayed too long.
Was Lydia watching this from remotely?
Yes, Lydia.
May it please the court, it's just us two. Attorney Xiomara Hernandez for the plaintiff, appellant ML. I'm here today requesting that this court vacate my client's level 1 classification or remand the case back to the board for another classification hearing. I would assert that the hearing examiner's decision was arbitrary and capricious and an abuse of discretion, as the hearing examiner made 2 specific errors in applying the regulatory factors to this decision. First, the hearing examiner erroneously applied risk elevating factor 16, which is, public place. In 1977, my client was convicted of annoyance of a child for asking people under the age of 10 if they wanted to play. I would assert that it was error for the hearing examiner to apply this risk elevating factor because it wasn't a sex offense. He wasn't convicted of a sex offense. And additionally, he didn't engage in sexual misconduct. So because of these reasons, I would assert that it was error.
To ask you a broader question, though, because, you open the file and you see level 1, no dissemination, and you think, what are we doing? So when I read your brief about risk elevating, risk mitigating, please disagree with me, but the sense that I have is, he's old, he did his time, he was SDP'd, it's time for him to be relieved of these obligations. That's your argument,
That's essentially my argument, yes.
As a matter of law.
That's where I was going next.
Yes.
So what case do you rely on to suggest even remotely similar facts to your clients? I mean, I appreciate the position that you're in, and I have to say, I mean, he recognized that he had issues and stepped up, and we don't see that very often, but nonetheless, this is an administrative law appeal, so we are so many layers up. Do you have a fact pattern that says that the examiner's findings here, based on these facts, were arbitrary and capricious?
I don't know the names off the top of my head, but I have cases where the case was remanded because of errors that the hearing examiner committed during the hearing, during the classification hearing.
I looked at your cases. I didn't see anything that really looked like this case.
I mean, I've had personally many cases that were remanded. I didn't cite to any of them, but yes.
But that's a procedural disposition.
Yes,
I think the difference here is that what we've got is a reclassification from level 3 to level 1. And at bottom, you are contending that it was arbitrary, capricious, legally untenable for the hearing examiner to reclassify this guy from 3 to 1 and not 3 to 0.
Well, I would say, had the hearing examiner not committed those 2 specific errors that I talk about, which is the application of risk elevating factor 16 and the non-application of risk mitigating factor 31, which is all the health issues that he has, had the hearing examiner correctly applied those 2 factors, my assertion is that he would have gone to the conclusion that my client does not pose a current risk.
When would your client next be eligible for review and redetermination?
Let's see. I believe, hold on one second. I believe 2023. So in about 1 year, yes, next year, yes.
So, again, following Judge Blake's lead and taking a step back a little bit, what you are asking us to do is to conclude that the hearing examiner engaged in arbitrary and capricious decision-making in concluding that the appropriate disposition here, as a first step away from level 3, was to move to level 1 while waiting for the next opportunity for reclassification.
I mean, what I would request is that it gets remanded and the 2 errors that the hearing examiner committed get corrected. And it maybe, who knows, maybe if they would correct those 2 errors, maybe the decision would still be level 1.
Level 1, and
then he
if on remand they result in a level 1, would that push out the date for an opportunity for review?
I believe it would, yes, I believe it would. I mean, I'm doing
how does that assist?
And I totally hear you. Many times I have talked to my clients about withdrawing the appeal so that they could just wait for the time period and reapply. But again, this is, I'm doing what my client wishes to do, which is continue with this
And we
appeal.
respect the work that you do and the constraints under which you do that work.
Can I just go back to the elevating, mitigating piece?
Sure,
So
yes.
the two things that you complain about are 16, which is public place, and 31, which is physical condition. But the hearing examiner did consider offense-free, advanced age, sex offender treatment, home and support system, stability in the community, right?
Yes.
And isn't it the examiner's job to sort of balance those, what are they, 5 risk mitigating against the 2 risk elevating, among other things, right?
Yes, but I would say that had the hearing examiner not applied risk elevating factor 16, maybe he would have arrived at a different decision.
So is it your view that if he did not apply 16, that your client would be relieved of his obligation to register?
I think there would be a good possibility, because as I indicated, my client committed this crime almost 40 years ago. There was only one governing offense. He did complete sex offender treatment, and one of the psychotherapists that was treating him indicated in a letter in 2011 that my client poses no risk to reoffend.
What does somebody in Doe's, or I guess in this case ML's position, what do they have to prove to be relieved of their reporting requirement?
That's a really good question. What they would have to prove is that they present
Zero risk.
Zero risk of reoffending. The fact that my client hasn't reoffended since 1983, and he was released from SDP status in 2005, it's a long time. It's a long time, and he hasn't committed any other offenses either. There's nothing else on his record. The last thing on his record is from 1983. So my question is, how long does a person have to live with this over their head? And I get what he did was wrong. I'm obviously not saying that anything he did was right, but how long?
Suppose he had sought, I mean, this was the first time he sought reduction in his classification level?
It is. He filed the application a while ago, but there was something that happened where the board must have lost it or something.
He was released from SDP in 2005.
Yes.
That was 17 years ago.
So like, I think 2011 he applied, and then something happened with the application, I don't know. So his attorney reapplied for him, I believe 2018 or so, 2017 or so. I mean, I will assert to you that for it to be remanded, so that at least those 2 things, in my opinion, could be corrected. And if the decision is level 1, it's level 1. But to have this over your head for such a long period of time.
So other than having to register, how else does the level 1 affect him? And I appreciate that having to register and failing to do so is a crime.
Yeah, I mean,
understand that.
there's housing issues that come into play, there's employment, he's on Social Security, so employment wouldn't impact him now. But if he wanted to move into, let's say, a housing project that they don't accept anyone that's classified as a sex offender, I mean, there are many things that would impact him.
So before we lose you on time, I just want to ask about the expert funds.
Yes.
Brother counsel makes the argument that they're waived. There was sort of, it looked to me like a general oral motion for funds loosely tethered to some depression. It didn't seem to have that definitiveness that our case law requires. Do you want to respond?
Yeah, I mean, it was an oral motion for funds that he made at the classification hearing. So there was nothing actually written down. She just said, hearing examiner, if you use any of the SDPs or any of the evaluations that my client underwent, please, allow me to get funds to hire an expert.
Nothing about how his special circumstances would be connected.
During oral argument, no, but it's in the record that in 1986, he was diagnosed with clinical depression, and he was getting treatment for it, and apparently he's off of it at this point because it looks like it worked. So there may be a connection between his mental health illness and his actions in terms of, his sexually offending, don't know, but if an expert would have been hired to testify regarding what connection, if any, the depression had, and also the treatment for the depression has in terms of his risk of reoffending and danger to the community.
Does the pendency of this case affect, I think the chief asked you this, but if this case is still pending, he can't ask for a reclassification, right?
He cannot.
Because this would be open.
Yes, he cannot.
So if it's remanded, is it still considered open?
I'm really not sure. Probably, yes.
Okay.
And if there's no further questions, I'll rest on my brief.
Thank you.
Thank you so much.
Mr. Chennai?
Thank you, Chief Justice Green. If it pleases the court, David Chennai for the board. I want to point out I'm a little bit at a disadvantage. I forgot my readers today, so I'm trying to go through this, going through my notes, kind of pulling the paper further ahead.
You know the material well enough to present your case.
These reclasses are tough. They're tough decision-making decisions for the hearing examiner because this individual clearly has done really well in the last 15 years. And the hearing examiner's decision really focused on whether there's a cognizable risk, which is kind of the standard I think the DSJC set out in 496501, cognizable risk. With the level 1 situation. Here, the hearing examiner found there was still a cognizable risk. If this case is remanded and the board has a new hearing, a full new hearing, then at that point, the reclassification would be 3 years after the new hearing. If the board just amends the decision, it goes back to the 3 years goes back to the decision-making, the original decision, which would be January of 2020. He's eligible for a reclass in January of 2023, which is next month. Of course, if this case is pending, he doesn't have that ability to have the hearing until this case is resolved.
You might not know the answer to this, and it's not in the record, but, I'm curious. Do people get classified as zeros and get relieved of their reporting requirements?
I have to say it's happening more regularly now because of mainly two things. The court ordering that it be every 3 years, three things. The second, that the board has to prove by clear and convincing evidence each time that the individual, the current level of danger and risk. And the third thing is that the hearing examiners are really focused on trying to look at these cases much more closely because, again, as time goes on and these individuals stay out of trouble, they're getting benefit of both aging and times. And I've seen significant case. I've seen a case that was very significant that back in the preponderance of the evidence days, we made him a 3. He was never going to be reduced from a 3, and 6 months ago he was reduced to a 1.
Let me ask a somewhat different question. Are there characteristics of level 3 classification that make it more difficult for an offender to reoffend than a level 1 classification? I understand that 3 is far more intrusive. And I'm just asking as a practical matter, are there aspects of the level 3 classification that would suggest that a period of time where an offender doesn't reoffend under a level 1 classification is more reassuring than a period of time when an offender doesn't reoffend under a level 3 classification? Or does it not matter?
The level 3 classification is what the board's position is that when you're a level 3, the dissemination on you is pretty active. Not only are you on the internet website of the board, but the community is posting your picture in places that you may go. The police actually, some police departments put your information on their cable network. So the board's position is that is a hindrance, theoretically, that if the public's aware, he's less likely to have opportunity to have contact with future victims.
It limits the opportunity to reoffend for so long as the level 3 classification is outstanding in a way that the level 1 classification does not.
Correct. The level 1 classification is, they're saying, there's still some risk, but we don't believe it's such that we have to notify the public in any way. In fact, of level 1, all they register, the only ones that would have information regarding him would be the police department, and they're not allowed to give out that information.
At the time, if we imagine a reclassification hearing occurring sometime in 2023, the fact that he has not reoffended during the 3 years he was classified at level 1 would mean something that he did not enjoy as a benefit when he went before the board the last time to seek reduction from a level 3.
Correct. Each 3-year increment that goes by reduces that risk as long as there's no further indications.
It's not just a 3-year increment. It's not just that he's 3 years older. It's also that he didn't reoffend while classified as a level 1 and not as a level 3, where he had some greater opportunity.
I don't think that that's been, I haven't heard that being discussed in the board, but I'm not part of the hearing unit's inquiries. I can pass that information along. That
It's not information, it's just a
Right.
question.
It is a discussion. I can pass the fact that that discussion occurred today. I am not sure the answer to that, and I would hesitate to say that that's correct, because, again, I don't have control over that.
It's not in the regulations, I take it.
And it's not in the regulations, and again, I think they're taking these cases on a case-by-case basis. In this case, it was a balancing of the individual's prior sex offending behaviors, the fact that at one point in his life he did have sexual deviancy, although the hearing examiner did point out in the last 15 years, it's apparent that he's been able to control that. How it will shake out when he reaches 18 years in January, if he gets the when he has his reclassification hearing, I can't guarantee one way or the other. And again, it's a weighing of, as you can see with this case, the weighing of those
Classic
different.
multi-factor test.
Right. And again, I think that more so than in the past where it was preponderance of the evidence, I think the hearing examiners are really looking at these reclassifications especially very closely, and they're trying their best to find the right balance because of the significance of even having the level as a level 1, but still the idea that if there's a cognizable risk, they should still have to register. And unless there's any further questions,
Why is he ML and not John Doe?
I don't pick the acronyms. I think that was actually either the attorney at the Superior Court. I actually had one Superior Court attorney just wrote his own SON number, and I said, you can't do that. If it gets remanded, someone else is getting the benefit of it. And he's like, oh, I didn't know that.
Well, let me just make the observation that it would be so beneficial for our doctrine if we had more pseudonyms and fewer numbers.
I agree, of course.
Way easier to remember.
Right, the board starts with a number, it's up to the council to use the acronyms that they wish to use. I personally get very tired of trying to remember all the numbers of different cases and which ones went to what, and when you get...
46501 or something?
Yeah, and then you get 22188, who has 3 different levels, and you get Doe 151564, who has a SJC case and an appeal court case on 2 different issues. In fact, that reclass just came up, and he was reduced, so we might not see him again.
All right. Unless there are further questions, which I do not see, that will conclude this hearing, and with it, our session today. Thank you all.
Thank you, Your Honor.
Jeanette.
Excellent job.
And thank you, Sam.
And Sav for all those times with that 5th case. That requires me.
What is the session? What is the recess?